Prayers, please give it to the bench clerk. He will entertain as far as practical. Give it to him.
Adjournment item number 18, my lord. Some accommodation today, my lord.
Item number
18, my lord. It will be taken after vacation, my lord.
18 is an order matter. Oh, hearing.
Hearing matter.
All right. You are for the petitioner.
Lordship.
Petitioner.
Petition.
You have informed the other side.
CGS have been already informed.
As prayed for by Mr. S. Bora, learned counsel for the petitioner with consent from the other side. Date. This
After vacation, any date.
list on reopening our first Tuesday
Lordship.
on such and such date for hearing.
Okay.
Lordship. Item 12 of today's session. Item 12 of today's session.
Item
12. So, Lordship, in this matter, we are required to file the affidavit, Lordship. The copy has been served yesterday, Lordship. So, today it will be filed. So, some time will be granted.
You are for?
I am for the government hospitals.
Have you taken consent from the
Yes,
other
yes,
side?
I am for the petition.
You are for the petitioner.
Well, it may be on 22.
As prayed for by Mr.
CKS Bora, Lordship.
C.K.
S.
as
Bora.
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 Learned counsel for respondent number
3, 2, 3, 1, 3, 1, 3, 2.
Ms. Chaudhary. You are there in that matter?
I am appearing for respondent number 2, Your Lordships.
Yes, you are wasting the judicial time, Mr. Counsel. Why are you not aware of which respondent you
1
appear
and 3,
for?
Lordship. 1
Huh?
and 3. 1 and 3.
For respondent 1 and
3.
3 with consent from the other side. With consent from the petitioner, list this matter after
22nd
22nd October.
on 22nd 10/2024 to enable the respondent to file their return in the matter.
and they want to file a reply.
I will file reply.
That you file after they file it. I'm
Yes,
not
yes.
noting all this. He has not yet filed.
He may be
Awesome.
he must serve a copy on me as well, Your Lordships.
Yes,
I
also.
think that is as per the rule.
Yeah, that's to all the parties.
Yes.
May I please have
That's
Lordship?
all.
Masuk.
Item number 26, Lordship.
Item number 26.
The Lordship, this matter will be taken up after orders item, Lordship. I have an urgency. This is regarding regular pension, Lordship. That was not given for DP, and government has provided me the last occasion copy of that. They have dropped the DP, so it will take very few minutes time to dispose of, Lordship. And petitioner is old person, Lordship, 68, 69 years old,
All right. Let's see how it goes.
Lordship. May be taken up.
Let's see how it goes.
Deep look.
May it please your lordship. I beg to mention item number 33 from the supply list.
Item number?
33 from the supply list.
Yes.
I'm for the petitioner, man. I'm for the petitioner.
What do you want?
Right. We will file additional affidavit, lordship. The matter may be come
You are for?
agriculture department, lordship.
As prayed for by Mr.
On behalf of R. Bora.
As your name.
ADAS.
Please don't
ADAS.
act like a proxy counsel. When this court is asking your name, please give me your name.
ADAS.
Yes, Mr.
ADAS.
As prayed for by Mr. Das on behalf of Mr.
R. Bora.
R. Bora, Learned Standing Counsel.
MSR, bro.
MS R. Bora, Learned Standing Counsel, Agriculture Department. With consent from the other side, list this matter after 2 weeks to enable the respondent to
Lordship,
file an
fixed on a hearing
additional
date, my
affidavit in the matter. Yes, next.
on a hearing date, my lord, after petition.
Next.
May it please, Your Lordship. Lordship, item number 27, Lordship. Kindly adjourn this matter for 2 weeks, Lordship. I have taken consent from the other side.
You are for
Petitioner, Lordship.
your name?
D. Kolita.
As prayed for by Mr. D. Kalita, Learned Counsel for the petitioner with consent from the other side, list this matter after
2 weeks.
2 weeks on a date to be fixed by the registry. Family pension.
Yes, Your Lordship.
Last time also there was no representation.
Yes, Your Lordship.
In
I
fact,
was
on
supposed
the
to
last three occasions.
Yes, Your Lordship. But instruction I have received, Your Lordship.
What is the instruction?
Instruction, the employees from APDCL. So sanction letter will be from APDCL only. I am for AGCL, Your Lordship. This is the instruction.
Standing Counsel AEGCL
Yes, Your Lordship.
is present. Stop.
For respondent number 3 and 5.
For respondent number 3 and 5.
Yes. And my name is wrongly reflected in the cause list and Fukon.
Ms. Pukan, I am disposing of this petition. Does it make any
Okay.
difference? It appears that on 19/11/2020, 2/2/2020, and 16/9/2024, on the last occasion when this matter was listed, also there was no representation on behalf of the petitioner when the matter was called. Stop. In view of the consecutive non-appearance of the learned counsel appearing for the petitioner, the instant petition stands dismissed for non-prosecution.
Oblige, Your Lordship.
May it please your lordship, my lord, two things, my lord. In the last occasion, your lordship can see the order passed by my lord Justice Ukanayan.
Records.
Yes, but unfortunately, it's in order. It is recorded that instructions and record to be placed by me, which is actually has to be placed by the department.
Yes, are you appearing, Mr. Chachi?
Lordship.
Do you have the records? Do you have the records?
Lordship, actually, yesterday evening only I have gone
You
through
want
this,
some
Lordship.
time to
Yes,
go through?
Lordship.
Let us have a look at it. MS M. Bhattacharjee, learned Senior Government Counsel for the state, submits that in terms of the order dated 16/9/2024, her office has received the records only yesterday and accordingly seeks some accommodation in the matter so as to go through the records to place the same before this court. Stop. Prayer is not opposed. List on?
My lord, earlier it was actually fixed on
List
24th.
on
24th.
24th.
24th, Lordship, I have difficulty,
Yes, please
Lordship.
tell me a date, Ms. Bhattacharjee.
27th, Lordship.
List on 27/9/2024.
Lordship.
27 September. Can it be on 26th, my lord?
26, Ms. Bhattacharjee?
Yeah.
All right, 26.
My lord, my spiral binding volume was there. May I take it, my lord? Not this paper book, but there was a spiral binding volume.
It doesn't look like there is anything spiral in the file, Mr. Counsel. Yes. Next
Maybe in the
matter,
court.
please.
Maybe in that court. I'll take.
Are you appearing in item 3?
No.
May I please, Your Lordship? Lordship, this matter is regarding
Mr.
the
Sahewala, where is your opponent?
my lord, from the last 3 occasions.
Absent.
There is no appearance, my lord. Lordship,
All right.
anyways, the petitioner is reinstated, my lord.
I am the.
The
he
Lordship may
reinstated.
close. Yes, please. Lordship may close the record.
It appears that, none appears for the petitioner when the matter is called. Stop. Heard Mr. M. Sahewala, learned.
Respondent number 2 to 4, my lord.
Learned
Pending counsel.
your ASTC.
Yes, my lord.
Learned Standing Counsel ASTC for respondent numbers
2 to 4, my lord.
2 to 4 and MS
MD Bora.
MD
Bora.
MD, right? MD Bora.
For
Learned
Standing
Standing Counsel Transport within bracket respondent number 1. It appears that on 7/6/2024 and 2/9/2024, when the matter was last called, also there was no representation on behalf of the petitioner. So, in fact, on 2/9/2024, i.e., on the last occasion when the matter was listed, this court has observed that if the petitioner remains unrepresented in the next court date, the instant writ petition will be considered for disposal in view of the letter dated 14 December 2020. Where is that letter?
My lord, it's there marked as X, my lord.
Since today also, when the matter was called, there is no representation on behalf of the petitioner, this court, upon perusing the letter dated 14 December 2021, apparent that
Serial number 18, my lord, on the second page.
he has been reinstated.
Yes,
That the petitioner at serial number 18 of the said communication appears to have been reinstated to the
post of driver, my lord.
to the post of driver.
My lord.
And as such, nothing survives, nothing appears to be surviving in the present writ petition. Accordingly, the petition stands dismissed for non-prosecution. Accordingly, the petition stands being infructuous, disposed of being infructuous.
Deeply.
Oblige.
May I please, Your Lordship?
Yes, Mr. Datta.
No, this is basically a covered case, my lord. What had happened, this petitioners.
Covered case, Mrs. Bhattacharya.
Lordship, no, we are supposed to obtain instruction, Lordship. Though we have written, Lordship, no instruction as such as here, Lordship. Lordship, my post is next week, Lordship. I think
Monday,
this is Monday, Lordship. Let us try, Lordship.
last chance. Because if it's a covered case, this court will dispose it off in the same line. Why so much
They
delay in finding whether it is covered or not covered?
They made recoveries, my lord. Those were asked to be refunded.
Anyway, Mr.
And
Datta,
again,
she
my lord,
wants
they're
to
paying.
verify. Let her verify. Yes.
Actually, what happened, my lord, is
Service
covered,
book.
my lord, but the service books of the petitioners are with the pension department. So we have requested to return back.
It's all right. I'm giving you
Yes.
time to verify. You verify, but
Only to find the service book.
yes, that is why I'm saying
Yes,
it did not be prolonged.
My lord,
You settle it.
my lord, that is.
When do you want? Monday? Wednesday?
Not Wednesday, Lordship. Either Tuesday or on Thursday, Lordship.
Then, my lord, I'll be on Thursday, my lord. Tuesday, Thursday.
MS M. Bhattacharya, Learned Counsel, you're appearing as Additional Senior Government Advocate.
Yes, Lordship.
Additional Senior Government Advocate for the State Respondent
That's
seeks,
for number 4, Lordship. Pension Department.
no, your designation in the
Yes, Lordship.
as
Same.
additional
Yes,
senior.
yes, yes.
In bracket respondent number 6.
Four only.
Respondent number 4 seeks some accommodation in the matter to apprise this court as whether this case is covered by
My lord, the judgment and order dated, my lord.
covered by the judgment and order of this court.
Yes, my lord. 9/8/2017.
Dated 9
8/2017.
8 2017
In WPC number 7739 of the
WPC number
7793
7793
/16.
oblique 16.
Yes.
Stop. Prayer is not opposed. List this matter again. Give Thursday date, huh? On Thursday.
Thursday, my lord. Oblige, Your Lordship.
Yes, Mr. Borua.
Yes, ma'am. May I please? My lord, this is
Affidavit in opposition.
yes, only instruction whether the director of municipal administration.
Yes, who's going to file?
My lord, last occasion, my lord, the department only told that they will open the instruction.
One affidavit is already filed, Lordship.
No, because the office note of 7 September says that no affidavit opposition has been received by the section till date. And the last order says
Lordship, one affidavit filed, Lordship.
one is filed.
One
that's right.
filed on 8/11/23.
That is there.
On behalf of respondent number 5,
No, that
Lordship.
is there, but
Now the only issue was, my lord, whether director of municipal administration approval is necessary.
who is appearing for the state council? 1, 2,
My
1,
lord,
3, and
last
6?
occasion TC Sutia.
Because Mr. A. Chakraborty, Learned State Council,
Lordship.
sought 2 weeks' time to file affidavit in opposition. And that affidavit, which is on record, is filed by R5.
Lordship, I understood. One instruction is there of the director of municipal board.
So you
Lordship,
file it.
No, Lordship. As per section 50, Lordship, it is the board only. So we are not the necessary party here.
Board has
Lordship.
filed their affidavit.
Board
Yes, yes.
means, Lordship, yes,
R5.
respondent number 5. But actually, we don't represent the board, Lordship. Here, the chairman, they
So
have
the
to.
main
they needs to
respondent
be-
is R5.
Yes,
Who
Lordship.
is appearing for R5?
R5, Lordship, I think government advocate, they have filed, Lordship.
You can appear for R5.
Lordship, as this post is of executive officer, Lordship, they are of additional charges, Lordship. Most of the time, additional deputy commissioners are of additional charges. But here, Lordship,
No, Miss Bhattacharya, a very simple question. This court
Yes,
is
Lordship.
asking. Are you appearing for the R5?
Lordship, respondent number 4 is the appropriate party. Respondent number 4, his appearance is required and his
R4?
affidavit. Yes.
And who is R4?
The chairperson, Bodapur Municipal Board.
Anyone appearing?
No, Lordship. Till date, I.
What happened to the notice?
They
Has been
needs to be, their appearance is
4 and
required,
5 is
Lordship.
the, my lord, municipal board.
No, Lordship, municipal board don't deal with these things. It is the board who
Mr.
works
Borwa,
independently.
The state is taking a stand that it is R4 who is the main respondent. Now, if you don't have him appeared, how would you get the orders executed
Yes,
in the
Lordship.
first place? Is it not in your interest
Yes.
to have his presence secured
Yes.
first?
Section 50 of the Municipal Act is very clear, Lordship.
So
My case
who, it appears that notice was deemed to be completed on R4 and they have not appeared. What is the matter?
My lord, the matter is regarding regularization. I am a employee of the municipal board. my lord.
Yes, this is.
And thing is that, my lord, my regularization has been taken by a resolution of the chairman, being a self institution. Page 23 is my appointment letter, my lord, appointed by the board, my lord.
Page
23. I was appointed in the year 2010 as junior engineer, my lord. And
Okay. This is by the
By the
chairman,
chairman.
lordship, chairman.
because it's a self institution,
All right,
Yes.
since this matter is for admission and there is no
Now-
representation on behalf of R4, let me admit it and issue
no, thing
notice.
is that, my lord, I'm going to retire next year, my lord. Only regularization has not been done and no scale of pay has been.
All right, I'm
And
admitting
there are
and issuing
many things
notice. You take
involved.
fresh steps. If they don't appear, we will dispose it
Yeah.
up on the next date.
And there are many
Uh,
things involved,
Heard
lordship.
Mr. B. Borra, Learned Counsel for the petitioner stop. Also heard MSM Bhattacharjee, Learned Counsel, appearing on behalf of
The state lordship.
respondent number One.
Except respond number 4, lordship.
or respondent
No,
number.
no, 4 and 7, except those.
So 1, 2, 3, 5, and 6.
5, 6, yes,
Stop.
lordship.
This petition requires a full-fledged hearing. Admit no formal notice as regards respondent number 1, 2, 3, and 5 and 6. As M. Bhattacharjee has accepted notice, has entered appearance. Stop. However, since there is no representation on behalf of respondent numbers 4 and 7, let notice by registered post AD be taken within a period of 2 days from today. List this matter for hearing
Yes.
on,
My lord, immediately after vacation.
give a date,
My lord, on 29, my lord.
on 29th so and so.
Since I am going to retire, my lord, next year.
Stop. In view of the fact that the petitioner is going to retire on
Next year, my lord.
retire next year, comma, an endeavor shall be made to dispose of this petition on the next date of listing.
Hello.
My lord, in this case, I mean, item number 6, my lord. My client,
Mr. Goswami,
my client has engaged Mr. Ashish Das Gupta as a senior advocate, my lord.
there has
He
been a
he
change of
expressed-
counsel.
Yes, as a senior counsel.
Or
He is
led-
to lead us.
He is not available today.
My lord, he has some difficulty and he expressed that the matter may be urgent for today or any other date may be taken.
All
Or it
right,
may
I
come
will
up
give
after
it,
vacation.
but it appears even on the last occasion there was a
Yes,
prayer, there was a similar prayer made.
Yes, my lord, that is.
Anyway, as prayed for on behalf of Mr. A. Das Gupta, Learned Senior Counsel, appearing in the matter for the petitioner, comma, which is not opposed by the respondent, list this matter after 3 weeks on a date to be fixed by the registry.
Along with item number 7, your lordship.
6 and 7.
6 and 7.
Analysis, my lord.
Your Lordship, my Lord, with regards to item number 8, 9, and 10, SLRC Council, Mr. B. Chaudhary is appearing for this matter, my
I
Lord.
cannot hear anything.
Mr. B. Chaudhary, SLRC Council is appearing for this matter, my Lord. He is occupied in another court right now, my Lord. Time being, my
But
Lord.
pleadings are not completed in this matter, Mr.
My lord,
Buragohai.
yes, my lord. I just take your lordship to one very important order. That is on 7th of June
All right,
2024.
let Mr. Chaudhary be here.
My lord.
Time being.
I'm obliged, my lord.
Yeah, please, lordship. Here the petitioner is selected way back in the year 2013 itself as a laboratory lordship. In this case, lordship, Mr. D.P. Bora is appearing. He has some personal difficulty and he requested me to pursue the matter for the day, lordship.
For the day.
For the day, lordship.
Friday?
Yes, tomorrow.
Tomorrow is Friday.
Friday.
Monday then?
Lordship,
All right, we can have it tomorrow.
Lordship, next
Kali-
week,
Kali list at Buddha, sir.
Lordship, if it's convenient tomorrow, Lordship.
All right,
because
tomorrow.
Tomorrow.
Uh,
Because she's waiting.
Mr. DP Bora.
D. Bora.
D. Bora.
DP Bora is
DP Bora.
Huh?
DP Bora is on difficulty.
This is item number 11, right?
11.
It is submitted that Mr. D.P. Bora,
Yes.
Learned Standing Council Health,
Health Department.
is due to personal difficulties not available in court today, and accordingly mention has been made to post this matter tomorrow. Prayer is not opposed. List this matter again tomorrow.
Okay.
Date,
Alright.
huh? Give date. Yes, Mr. Ahmed.
Today's matter is fixed for final disposal. The matter. The fact is this.
Where are the respondents?
This one, Mr.
You want final
This is
disposal,
Bora.
your counterpart are missing. At best, you could have asked your junior to ensure his presence if you are so serious to have a final disposal. Tuesday? I'll have it on Tuesday. Heard Mr. A. Ahmed, Learned Counsel for the petitioner. None appears for the respondent when the matter is called. List again Tuesday.
Ahmed.
J. Ahmed, sorry. Yes, Mr. Chaudhary.
My lord, this petition has been laid for the consideration, my lord. Whether, my lord, an employee who belongs to a different cadre, my lord, can be reverted back to another cadre, my lord.
Mr. Mohanta, affidavit's not filed.
He already filed. He has filed it yesterday evening. He has filed it, my lord.
Because it's not on record.
It's not on record.
It's not on record. So we'll have it on another date.
Yes.
Are you filing a rejoinder?
We are filing a rejoinder, my lord.
So you want some time for that?
10 days, my lord.
All right. As
On
prayed
27th, my lord.
as prayed for by Mr. J. Chaudhary, Learned Counsel for the petitioner, list this matter on
27th.
27/9/2024 to enable the petitioner to file the rejoinder against the affidavit in opposition filed by the respondent number
One and two.
by the respondent
One
number,
and
by the respondents. Stop. Let registry since the said affidavit in opposition filed by the respondent yesterday, i.e. so and so date, is not available on record, comma, let registry verify and place the same on record.
My lord, there is one more thing, my lord. In the affidavit in opposition which they have filed, my lord, they have made a statement about the rule of 2019. That rule is not available in the public domain, my lord.
I'll give a
My
copy.
lord, we may give a copy to
Today
the-
itself I'll give a copy. Don't worry.
And my lord,
You do not have to
My
mention
lord, I'll
this
give it.
before this court.
I'll
Mr.
give it.
Mahanta is a very accommodating
My lord,
person.
I know, my
You
lord.
tell him and he will give you a
Right now I'll
photocopy.
But there is one more thing, my lord.
Yes.
My lord, this prayer for my lord, consideration of the interim prayers on the 27th, my lord.
If it is there, it will be there.
My lord,
Today is for admission, not
no,
motion.
it is there, my lord. It is there.
If it is there, it will be there.
My lord.
Yes. Asene? Huh? Oh. Why am I doing that?
Date is your worship.
Yes, please.
Some instructions was for last proposal.
What about service?
We have
Petitioner has claimed honorarium for the post of chairman was holding in the Assam Military Development Corporation. We have taken instruction. He is not entitled for house rent allowance and car rental. And in fact, he has taken more advance from the corporation. And we have taken steps for several occasions.
This case is for what?
For payment of outstanding dues.
Payment of
Outstanding dues.
Honorarium.
13 million.
outstanding dues. Honorary
Honorarium, he was holding the post of chairman. During
chairman.
2010 to 2016.
According to you, he is not entitled.
He is not entitled.
Why don't you file an affidavit?
We filed the affidavit.
Filing the affidavit, you
Lordship.
cannot be taking him
Because
from
he had taken
by
Lordship.
surprise.
Lordship.
You're as prayed for by Mr.
KL Gupta.
KL
Gupta. Gupta.
KL Gupta, Learned Standing Counsel, lists this matter after 2 weeks to enable the respondent to file the return in the matter on a date to be fixed by the registry.
I'm obliged, ma'am.
May it please your lordship.
Yes,
Lordship, this matter may be taken up after some time, my lord. It's in your
it's an order matter. Why is it come for orders?
Lordship, there is an IA, my lord, preferred by them, my lord. So,
Who's filed the IA?
by the respondent.
IA for?
Give it to me.
All right, after some time.
Let's move.
May it please your lordship. In this matter, my lord, the finance department has preferred a review. It's an old pending matter, my lord. I don't have copy of the review petition as well as the affidavit filed by my department, IWT. I'm applying for a certified copy. My lord may grant me some time.
Your name?
K. Kashyap.
Heard Mr. K. Kashyap, Learned Counsel for the petitioner. Stop. Also heard MSMD Bora, Learned
Standing Counsel,
Standing Counsel?
IWT.
IWT. Stop. Anyone else there? Mr. Finance, MS H. Borwa on behalf of P. Nair, Learned Standing Counsel Finance. MS MD Bora, Learned Standing Counsel IWT, submits that she has applied that her office has applied for the
Certified copy of the review petition
certified copy of the review petition
filed by the finance
filed
department,
by the finance
department,
as
well as the affidavit filed by the department,
as well as the affidavit filed by the finance department,
IWT.
filed by the IWT, and her office is yet to receive the same, and accordingly seeks accommodation in the matter. Prayer is not opposed. List this matter again on. It's all matter. Give a date.
After vacation.
After vacation, Thursday to be first Thursday.
Deeply obliged, my lord.
May it please your lordship. My lord, before I proceed, my lord, may kindly take up item number 10, my lord. In
10.
item number 10, there has been an affidavit filed by the respondent. Well, briefly, if I may submit, my lord, on 7th of June 2024, on 7th of June, my lord, 2024, this court, my lord, heard the issues that are involved, my lord, and a direction was given to the, my lord, the Learned Counsel appearing for the State Recruitment Commission, my lord, that you produce the records pertaining to the status of these petitioners, how much they have secured in the selection process relating to, my lord, the recruitment drive, my lord. Like in the, my lord, in the merit list, my lord, they are required to prepare a list in which, my lord, the name of all the candidates who has participated has to be reflected, my lord, which is the mandate of the rules, my lord, recruitment rules, which
You have?
Lordship, I have the result in the seal cover.
in the seal cover, it was directed to be produced, my lord.
Yes, I can see it is sealed.
Yes.
Now,
But before I open it,
my lord,
these matters, can it be disposed at the admission stage?
Yes.
Otherwise, I'll admit it and post it for hearing.
my lord, the difficulty is,
Lordship,
my lord, may I just submit, my lord, but difficulty is the recruitment process has been almost completed, my lord, and we are, my lord, anticipating, my lord, a fresh recruitment drive would be started. And in fact, my lord, they did started a new recruitment drive in which, my lord, recently, 2 days back, news came out, some paper leak was out in the same recruitment process, my lord. So, my lord, we are anticipating, my lord, if my lord, we are not protected by any order of this honorable court, then they will come with this plea.
Let's do it like this. So then I'm posting this matters on next week Thursday.
Any date, my lord, any date.
For
convenient.
final disposal.
Yes, my lord. That will be
Till
done.
then, you retain this.
And Lordship, in the meantime, I have not filed the affidavit.
Oh, you have not filed.
Yes.
When
my
you
lord.
file your
That-
affidavit,
In the meantime, I have filed.
can you file it before Thursday?
Yes.
You file it before Thursday. Mr. B. Chaudhary, Learned Standing Counsel,
SLRC.
SLRC seeks some accommodation in the matter for filing the return. for filing return. For filing return. Stop. Prayer is not opposed. It further appears that in terms of the order dated 7/6/2024, the records relating to the marks obtained by the petitioners as well as the marks obtained by the last selected candidate in the category of women, men, EWS within bracket general and OBC has been received by the Learned Standing Council SLRC in sealed cover. Stop. Let the same be retained with him till the next date of listing. List this matter? Yes. Tell me a date.
Any date subject to your lordship convenience before the ensuing break, my lord.
No, you give me a date, both
Yes,
of
ma'am.
you, because this affidavit has to also come.
Lordship on 26th or 30th.
Did you? 26th or 30th?
26th of, yes, my lord.
26th?
26th, my lord.
It will return for you.
I'm highly obliged, my lord. In all the items, my lord, similar order would follow, my lord.
8, 9, 10.
8, 9, 10, my lord.
Let me just mention that on the next date of listing, an endeavor shall be made to dispose of these petitions at the admission stage itself.
I'm deeply obliged.
It is needless to clarify, huh?
Deeply obliged.
Yes.
May I please, Lordship?
Yes.
Lordship, we were supposed to bring the relevant records, Lordship. So some time may be granted to bring the records, Lordship.
None appears for the petitioner when the matter is called. Stop. MS?
P. Rava.
P. Rava, Learned Counsel, appearing on behalf of respondent number?
For CGC, Lordship.
Learned CGC seeks 2 weeks' time to produce the records as called earlier by this court. Stop. Prayer allowed. List after the vacation of the date. List on such and such date. দুটা বজা মেটাৰটো এইটো না 22 কি হ'ল no what about 20 yes
Lordship, my senior is on leave on another court.
Yes, your senior is behind you. Yes, Mr. Deori. Dismissal from service.
Yes, Your Lordship.
Why were you dismissed?
Your Lordship may kindly.
What did you do, Mr. Deori?
There are allegations that I was the senior manager, Your Lordship. There are some negligence on my part, but Your Lordship, the punishment it was imposed, termination service is too harsh.
Senior manager?
Yes, Your Lordship. In Polton branch.
What is the negligence alleged?
Your Lordship may kindly peruse the statement of allegation.
You want to regain your breath? It looks you have come running.
56, Your Lordship.
50?
56. Page number 56, Your Lordship.
Yes.
55 with the article of charge, Your Lordship. May I read the article of charge? Condorpo 55, Your Lordship.
55?
55, the charge, article of charge.
Yes.
Sri Condorpo Kumar Kolita, Your Lordship. May I read, Your Lordship? Sri Condorpo Kumar Kolita, senior manager, presently under suspicion while functioning as branch head of Polton branch from 8/10/2012 to 16/11/2013, has allegedly committed several acts of omission and commission, details of which are mentioned in the statement of allegation for which Sri Condorpo Kumar Kolita is charged as under. Sri Condorpo Kumar Kolita has failed to take all possible steps to ensure and protect the interests of the bank and discharge his duties with utmost devotion and diligence, which is violative of Regulation 3(1) of UCO Bank Officers Employees Conduct Regulation 1976 as amended. Sri Condorpo Kumar Kolita has acted in a manner unbecoming of a bank officer, which is violative of Regulation 3(1) of UCO Bank Officer Employees Conduct Regulation 1976. Sri Condorpo Kumar Kolita, while performing his official duties or in exercise of powers comments on him, had acted otherwise than in his best judgment, which is violative of Regulation 3(3) of UCO Bank Officers Employees Conduct Regulation 1976. Sri Condorpo Kumar Kolita has failed to take all possible steps to ensure the integrity and devotion of duty of all persons for the time being under his control.
But what are these steps that they are alleging that you have not taken?
Your Lordship, page number 56.
Because these 1 to 4 does not indicate
Yes, sir.
the content. It's only saying that you have acted in an unbecoming manner.
Yes.
You have not taken the steps which were required to take. But what is these? What are these steps that they are talking about? Page?
Page 56, Your Lordship.
Yes. Sanction disbursed.
Sanctions and disbursed loans, Your Lordship. May I read, Your Lordship?
Yes, please.
Sri Kandapur Kumar Kalita, Senior Manager, Rihabari Branch, while posted as branch head of at BO Fortune Bazaar from 8/10/2012 to 16/11/2013 has committed following acts of omission and commission. Sri Kandapur Kumar Kalita sanction and disbursed cash credit limits to different borrowers in gross violation of banks' rules, regulations, and procedures.
Serious allegations, Mr. Deary.
Yes, Your Lordship.
Allegations are serious.
Yes, Your Lordship. Allegations are serious, Your Lordship. I'm not on the allegations, Your Lordship. May kindly peruse the inquiry report, Your Lordship. The last.
And this chart, what does these indicate? These are the things
These are
which you
the-
have not done.
Yes, Your Lordship.
Processing of the borrowed account was not done as per loan policy.
Yes.
Loan was sanctioned single-handedly. So basically, procedural requirements are not followed.
Yes, Your
In
Lordship.
short, that is the correct.
Exactly.
No, Your Lordship.
Okay, I'll come to you. You take your seat.
Yes, sir.
Yes.
The inquiry was conducted, Your Lordship, but I will like to point out one thing, Your Lordship. There was one witness which was examined, and he was the person who has exhibited all the documents, Your Lordship. Page 91. Sorry, not 91, Your Lordship. Sorry, Your Lordship. At page 98. Copy kita. Copy kita ko. So type this one ke mata ko. Type this one.
Yes.
Your Lordship, may kindly peruse page 98 for a moment. Third paragraph.
Yes.
In the course of inquiry, proceeding, the PO submitted 155 sets of documents, all of which being relevant to the allegations of subject charge sheet, were accepted by EO as management exhibits. A copy of these sets of MEs were given to the CO for information. The PO produced one management witness named Mr. Topon Chakraborty, manager of Circle Officer Guwahati, UCO Bank, presented the management case through examination of the MW, as also by submission on the basis of ME. So my respectful submission, Your Lordship, in this regard is that there are 158 documents and only one witness, and this particular witness is neither the executor of the document nor the manufacturer of the document. Your Lordship. Only one witness, he is examining.
Who is he?
He is one Topon Chakraborty, Your Lordship. He is a manager of Circle Office, Guwahati.
So he is not competent to exhibit?
He was not competent to exhibit.
Why?
Because
have you taken these grounds at that time?
Yes, Your Lordship.
Where?
Yes, Your Lordship.
But he's a manager. These are official witnesses.
Yes, Your Lordship. But the documents, this is one of my submissions, Your Lordship. I would like to.
I don't think there can be that can be said he is not competent because he is officer of that.
No, true, Your Lordship. But I would like to rely on a
official
judgment of the
witness.
Supreme Court, Your Lordship.
There is some bar.
No bar, Your Lordship. But the only submission, Your Lordship, may kindly peruse it's Supreme Court judgment, Your Lordship.
No, I'll go to the judgment, but in here, where have you objected?
Where
have you taken this objection? Did you cross-examine the manager?
No, Your Lordship. He was not cross-examined.
Why? He could have been cross-examined on this point.
Then Your Lordship may kindly find to come to
This is an inquiry.
This is an inquiry.
Both parties were allowed,
Yes, sir.
isn't it?
Yes, sir.
Proceedings, petitioner as well as representative is present.
Yes, he could
And
have
they have not raised
cross-examined.
an objection to that.
He could have raised an
Yes, Your Lordship. He did not
objection.
avail. He did not avail.
That he did not.
Yes. Then Your Lordship may kindly peruse page 137, the findings.
One second. And management only witness, huh?
Yes, Your Lordship. Only one.
Yes, page
Page 137, Your Lordship. After the inquiry, the findings by the inquiry officer.
137.
137. Down below, Your Lordship.
Yes. Findings, Mr. Dury?
Findings. So after carefully going through the allegations assessed above, vis-a-vis the evidence produced and submissions made by both the PO and the POCDR, and after applying my mind rationally, I amend below my finding in the matter of particular charge against the CEO, Mr. Kondapur Kumar Kalita. So, Your Lordship, page 138 has failed to take all. So these are the charges that I read. All are proved, Your Lordship.
All proved.
This is my inquiry report with finding on a subject charge sheet, which has forwarded the disciplinary officer for taking action as deemed necessary and appropriate by him in the matter. Then, Your Lordship, the page 139.
Yes.
This was the letter which was sent to me, the second so-called reply, Your so-called notice, Your Lordship, after the inquiry. Your Lordship, may I read, Your Lordship, page 139. Yes. We are enclosing here with the inquiry report dated 25/9/2017, submitted by Sri P. Pal, AGM, retired inquiry officer, for your comments on finding of the inquiry report. On careful examination of the report, it is observed that out of 7 allegations, allegations number 3, 1, 2, and 3 have not been presented by the PO, but other allegations have been held substantiated according to the
what does it mean, have not been presented by the PO?
Your Lordship, these are the allegations which were not proved. These were also allegations, but these were not proved. Your Lordship, may kindly...
This letter is from the bank.
Yes, Your Lordship.
To the inquiry officer.
To me, Your Lordship.
To you.
To you. Then, Your Lordship, the next point, the next paragraph. Since I concur. Now, before the disciplinary authority came to a finding, Your Lordship, he has concurred with the finding of the inquiry.
This is not an open mind.
Yes, Your
predetermined mind.
Predetermined mind, Your Lordship.
No, Your Lordship.
Yes, since I concur with the above findings of the inquiry officer that charges number 1 to 4 are proved, you are advised to submit your comments.
After submission of the inquiry report.
Correct. You
After
see
submission,
the stage between completion of inquiry report and till you take a decision on the inquiry
No,
report.
Your Lordship, inquiry has been completed.
The delinquent employee has to get after this stage the inquiry is completed. Till you take a call on the penalty, the delinquent employee has a right to show that the inquiry report should not be accepted.
No, Your Lordship, may kindly come to inquiry report. After it has been proved, then only it has been made, Your Lordship. The inquiry report has been given.
Sorry?
Inquiry report has been given to the petitioner.
No, I understand.
Where
but
the
Mr.
charges
Counsel,
has been proved.
why the inquiry report is given to the delinquent? Please
If he
explain.
has any other further remarks on it.
That's right. So at that stage, you have to have an open mind.
Your Lordship, may kindly come
You
to page
must
number
have an
138.
open mind. Yes, are you carrying that Utpal Rajpal's decision, Justice Bhuyas?
No, Your Lordship. I will produce it, Your Lordship.
You have that?
Yes, Your Lordship. I remember.
And there is, I think, one of another from this court in these points.
Yes, Your Lordship.
2 are exactly on this point at the second show cause notice.
Exactly.
Because even at the stage of the second show cause notice, it has to be one with an open mind, fair and an open mind. Very, very essential.
Yes, Your Lordship.
These requirements cannot be given a go by.
True, Your Lordship. Very true.
Are you not carrying the authorities today?
I'm carrying, Your Lordship. But
Which one are you having?
The Supreme Court judgment, Your Lordship.
Which one? You have seen those decisions?
Yes, Your Lordship.
Have you seen those decisions?
No, Your Lordship.
So I can have this on Tuesday. You have a look at those decisions.
Yes, Your Lordship.
There are decisions of the apex court as well as of this court, specifically at this stage. You see, the purpose of supplying the inquiry report to the delinquent is to give him an opportunity to show that you should not accept the inquiry report. Correct? But at that stage, if you have already accepted it, then where is the fairness? Where is the basic concomitant of the principles of natural justice? So look into that aspect.
Yes.
Tuesday, Your Lordship.
list again. Hearing remain inconclusive, list again on Tuesday.
I'm deeply obliged.
Please, Your Lordship.
Finance Department, some records was called, Mr. Sinha?
Yes, Your Lordship.
Yes, records. Mr. Nair, you have the records. Since when records has become some loose papers, Mr. Nair?
No, Lordship, Lordship will go through this.
Yes, what is this?
I am told, Lordship, the relevant file being number so and so could not be traced in the department in spite of best report. Accordingly, a affair is lost in the Dispur police station.
You want some time.
So far as this particular record is concerned, that could not be traced out. That is one aspect. One affair has also been lost. So far as government, it is not available with the government. It probably some portion may be available with the directorate.
So then you find out.
Yes, that I have not inquired yet.
Because otherwise it does not reflect good.
Yes.
How can the records be not available? There must be some duplicate records or photocopies, second copy.
Yes.
Anyway, I'm not getting into all this. I will simply say that despite that the records has not yet been able to be located, and therefore you are seeking time. I'll say that. Mr. Sinha?
Yes, Your Lordship. One more thing, Your Lordship. We had filed an IA prior to last date of hearing, indicating that they have advertised the post, Your Lordship.
That I will consider later. Let the records first be given.
Yes, Your Lordship.
Yes,
My only prayer is
Mr.
that in
P. Nair, I always get confused. It's Nayak or Nair?
Nayak Lords. Anyway.
P. Nayak, Learned Standing Counsel for Finance, submits that though the records were directed to be produced on the next date of listing by earlier order of this court, his office has received correspondence from the secretary. This is secretary to the government of Assam.
Yes.
From the secretary to the government of Assam by letter dated 21/8/2024 that the relevant file being number FEB 206/2017 could not be traced in the department in spite of best report, and accordingly a FIR is being lodged in the Dispur police station on 3/9/2024. Stop. It appears that the secretary to the government of Assam accordingly requested the office of Mr. So-and-so standing counsel for further time. Stop. Considering that the records are essential for effective adjudication of the list in hand, list this matter after
4 weeks score. 4 weeks score. After 4 weeks score.
After 4 weeks on a date to be fixed by the registry, to place to enable the finance department to place the said records on the next date of listing. Stop. It is needless to be clarified that since there is an interlocutory application pending in the matter, if the said records are not placed before this court on the next date of listing, the said interlocutory application shall be taken up for disposal.
Your Lordship, may I just pay one thing? It's already Your Lordship has indicated that it's a parted matter. So it should
Parted matter?
Yes, Your Lordship. On last occasion, Your Lordship has heard it at length. So Your Lordship has directed it to.
It's not a parted matter.
But Your Lordship will indicate that. That's what I'm saying.
Because it's not recorded. It's not a
Because
parted
His Lordship
matter.
has heard it considerably. So in that.
No, but I don't even remember what this matter is, Mr. Singha. Yes, next matter.
Lordship, I am appearing for FPSC, Lordship.
I'm appearing for this one.
Give your names. None appears for the petitioner when the matter is called. List after 4 weeks on a date to be fixed by the registry. B. Gogoi. Standing counsel?
GAD.
G. Yes, Ms. Bhattacharya.
May please, your lordship.
Mr. Das, you're appearing for?
AIDC, my lord. Respondent number 2 and 3.
Yes. What is this matter?
Lordship, matter relates to lordship.
Penalty. Penalty.
No, lordship. Selection and appointment, lordship. Lordship, what happened in this case, lordship? Assam Industrial Development Corporation issued an advertisement, lordship, in the year 2018, lordship. Kindly please space 10.
Post of assistant legal manager.
Yes, lordship. Space 10, lordship.
Yes, please.
Page 10, lordship. Two posts. One is Deputy General Manager, Personnel and Administration, and another is Assistant Manager, Legal. One post, so I am concerned with second one, lordship.
You are concerned with
Assistant Manager, Legal, lordship.
one second. The first is that
And Deputy General Manager,
deputy
Personnel and
A,
Administration.
and then B, assistant manager. You are
Yes,
concerned with B.
Yes, yes, lordship. So, in pursuance to that advertisement, lordship, I have applied, lordship, and lordship, selection was held, lordship. For the said post, lordship, kindly see that was held on, lordship, in the year 11/7/2018. Interview was held.
4/5/18 is the note.
Date of advertisement.
The advertisement.
And interview was held on 11/7/2018.
11/7/18
So I
interview.
appeared along with other selectors.
And then
No result was published, lordship. So I submitted various RTI application for publication of result. So nothing has come out. So I filed this writ petition for publication of my result and, lordship, for consequential relief. Then the AIDC has filed one affidavit, lordship.
so in this writ, your prayer is for publication of the result.
Result and consequential relief also, lordship. Then they have filed one affidavit.
Yes.
lordship.
What do they say in their affidavit?
Yes, lordship.
Mr. Das, please take your seat.
Well,
This is a hearing matter.
Well.
Yes.
In their affidavit, lordship, kindly see page 12.
Page
12. Affidavit filed by the respondent number 3, lordship.
internal page 12.
Yes, lordship. This is the minute.
One second. Page 12 is annexure 4.
Yes, lordship.
Yes.
This is the minutes of the selection committee meeting held on 11/7/2018. That means the date of interview for the post of assistant manager, legal, so and so.
Yes.
Lordship, first, second, third, fourth para, with the approval of the competent authority, all the suitable 18 candidates were called for the interview schedule on so and so date, so and so time, but only the following candidates attended. So my
15
name
candidates attended.
13, lordship.
You are serial number 13.
13, lordship.
All right.
Then next page, lordship. The individual grading of members of the selection committee on the basis of experience, professional knowledge, general knowledge, and personality, etc. interview are detailed below. So my name is, lordship, third one from below, lordship.
Yes.
I got 27 marks.
Yes.
On the basis of average total marks obtained by the individual candidate, the merit list is prepared, detailed below, so and so.
You are
first.
not there.
I stood first, lordship.
Oh, you are there.
Yes, lordship.
You are at serial number first.
Yes, my name.
Appointment not given to you.
No, lordship. Then lordship kindly see. That is in the year 2018, lordship. 11/7/2018.
Yes.
Then next page, lordship. Page 14. 25/10/2018. One letter was issued by the managing office order, lordship.
Yes.
Mr. P. Bora, general manager in charge, is hereby directed to inquire into the recruitment process followed by the corporation for
Okay.
recruitment of assistant manager, which was advertised in the Assam Tribune. Then so and so.
All
He
right.
is hereby directed to submit a report as soon as possible. That was given directed on 25/10/2018, and no report was submitted. After 2 years, before the date of his retirement, that is the next page, lordship, page 15, lordship.
Before whose retirement?
That P. Bora, that concerned inquiry officer, that is 27/7/2020. After 2 years, he submitted the report, lordship. He retired on
2
30.
years he took to submit a report.
Yes, lordship. That is my categorical statement in my reply, Lordship. He retired on 37/2020. 37/2020. Before his retirement, 2 days he submitted this report. Next page is the report, Lordship. Page 16.
Yes.
This is a long report, Lordship. Lordship, kindly see page 19, Lordship.
This is the report submitted by this person.
That inquiry officer.
Yes, page 19.
Yes, Lordship.
Yes. Yes.
Lordship, in the first, second, third paragraph. Another fact has been noticed in respect of submission of document by one applicant, Miss So and so, that means myself. Her application was received of our office on 19/5/2018, perhaps without any supporting documents for her age and qualification. Subsequently, she submitted.
Perhaps. What does perhaps mean? Perhaps.
Perhaps.
Yes.
Further, Lordship, from
subsequently, please read.
Subsequently, she submitted her self-attested supporting self-attested copies of educational documents on 11/7/2018 after the interview directed to the manager personnel AIDC, and the same is sustained by her application. Substantiated by her application to the managing director on 10/5/2019. Further, the following is observed. Though she quoted as an SC candidate in her application, she submitted her documentary evidence only after the interview. Her experience evaluated is 24 years.
Bhattacharya, how can this court in while exercising jurisdiction under Article 226 go into all this?
But
it appears that there is an application of mine. Yes, you are right. It appears that the inquiry officer took 2 years to submit this report.
Exactly.
But it appears there are substantial. You see, we cannot review this decision. This court is not the appellate.
I understand.
Correct.
But
Now the decision making. Now it only because it took 2 years. Can it be said that this decision is
I am not challenging
actuated with malafide?
I have not. In fact, I have not challenged this report also. I have got from the affidavit.
What is your challenge here?
My prayer was that to publish the result and consequentially.
Now that they have already done.
Published, but thereafter, Lordship, they are.
Hasn't your writ petition?
Has
it not become infructuous?
Otherwise, also there is another plea in that their affidavit that 1 year time is already expired from the date
That
of.
is also there.
But there is nothing mentioned in their affidavit when they approve the select list.
No, I am not on that, Ms. Bhattacharya, because you see, you have approached this court with a very specific prayer.
Exactly, for publication of my result.
Now it appears that they have taken a conscious decision of conducting an inquiry, and therefore the results were not published. Now the required report has also been given. So you have not accepted the selection, correct?
Yes,
what is your final decision for?
Final decision, madam, we could not take because of the pendency of this writ petition, madam. After the inquiry report is submitted.
So you are sitting also silent?
Yes.
No, but then how this writ petition, is it not infructuous?
Practically.
You have to be fair to the court. You are an officer of the court, Mr. Charji.
Yes. So
it appears you may have grievance.
Yes.
I'm not saying that you don't have any grievance. You may have a grievance, but then
I was the legitimate
then that has to be taken up in an appropriate proceeding.
Yes, I stood first. So I was some legitimate.
That's right. Yes. But you see, when you approached this court, you wanted only the results to be published.
And also consequential relief.
Correct. But consequential relief is what? If for appointment, but they have not. They have instead. If your case was that serial number 2 has been appointed, I could have understood.
Exactly. No,
that is not the case.
No.
They are now. How can this court issue a mandamus that you
not?
The court cannot.
No.
The limitations are there, isn't it? You withdraw,
or that will be better.
That would be better.
Yes, sir.
You file. If anything is there, I'll give you the liberty. All right, Mr. Das.
My lord.
Heard Miss. Item number 25. 25, right?
25.
Heard MSP Bhattacharya, Learned Counsel for the petitioner. Stop. Also heard Mr. S. Das, Leonard, Leonard Standing Council,
Standing
Cooperative Department. It is, huh?
AIDC.
Leonard Standing Council, AIDC.
AIDC.
Within bracket, respondent 2 and 3.
2 and 3.
Respondent numbers 2 and 3. And Mr. G. Bordoloy, Leonard Standing Council, Cooperation Department. The respondent numbers 1. Ms. Bhattacharya, Leonard Council, appearing for the petitioner, submits that she has received, that she has been instructed, she has received instructions for withdrawing the instant writ petition with liberty. Prayer is allowed. Petition stands dismissed on withdrawal with liberty.
Obliged.
Highly obliged.
Sorry, Malot. I can know 24 hours there, Malot. Just.
You want your name to be recorded?
Malot.
24,
Malot.
24. 24 order is passed. I don't remember what order I have given.
None appears. In fact,
Oh,
Malot.
none appears. All right, your name will be recorded. All right, Mr. Goswami.
Okay.
All right.
Maybe fixed, Malot.
Be grateful that your name will figure in the order.
Sorry.
Yes, this is the item which you had mentioned in the morning for an upgradation.
Lordship, petitioner is bedridden, very ill.
Now you understand why I did not at that moment upgraded this matter. It is not even 12 o'clock and your matter has reached. Yes.
Actually, Lordship, petitioner is bedridden. Old
Yes, there's
person,
no
that's
problem.
why. Lordship,
What is the matter?
Matter is, Lordship, I'm praying for regular pension and I was suspended. Thereafter, Shoko's notice was issued. Inquiry officer was appointed. Inquiry report of 2010 was there, Lordship. Thereafter, I was reinstated, Lordship. Thereafter, I retired in 2016, Lordship. And we are on 2024, Lordship. But till
What is your prayer in this petition?
prayer is for regular pension because, Lordship, throughout this period, 4 increments, 1 promotion is due to
Prayer
me.
is regular pension.
Regular pension. 4 increments and 1 promotion to the post of superintendent was due to me, Lordship, but that was not given to me.
Why regular
Now-
pension is not given,
now-
Mr. Achari?
Criminal case is pending, Lordship.
Criminal case is
Yes,
pending.
and there are departmental proceeding. Lordship may kindly refer Lordship's order on 29/7/24.
In this matter?
Yes,
Yes,
Lordship.
29/7. 29/7.
Yes, Lordship.
This is not my order.
Anyway,
No, then
This
you must
honorable
say
court's
this
order.
the court's order.
Court's order.
I thought I have passed some order. Yes.
Accordingly, Lordship, this has been disposed of and I have placed the instruction. Actually, they kept the matter pending, Lordship.
Let
for
me just
long. Yes, Lordship.
read this order.
Lordship.
You can hire, sir.
Yes, has the departmental authority passed any order?
Yes, Lordship, I have provided. Lordship, I have provided. It's on 5th August 24, Lordship.
Have you given a copy to the other side?
I have, Lordship.
This has already been provided to the person concerned, Lordship.
So it has been dropped.
Yes, Lordship.
Then why are you not giving whatever is to be given?
Lordship, this provisional pension, Lordship, if he has not, Lordship, he is entitled to all this,
Yes,
Lordship.
so whatever-
Not the final pension
Lordship-
till this.
No, then you
twice.
give it. If the
Lordship.
departmental proceedings have been dropped,
Lordship.
there appears no reason for why
Lordship.
the regular pension and the other entitlements in law, whatever is entitled.
Lordship, yes.
Yes, Mr. Nayak, you want
Provisional
to?
is entitled.
Sorry?
DP is no more there, but the criminal case is
No, but you see, since the departmental proceeding has been dropped, is the petitioner not liable to be paid? Criminal case is criminal. Whatever happened will happen, but your departmental proceedings have been dropped, Mr. Nayak. You see that order 5th August?
Yes, that DP has
Then
been dropped.
how
But
can you not?
He is entitled to provisional pension. That will be considered by the department law.
Yes.
But till the finalization of the criminal case, pension may not be finalized.
Regular pension.
Where is the bar?
That is section 21.
21.
Rule 21
Show me.
pension rule.
Show me. Because otherwise, if that is there, I can just dispose it off by
Yes,
saying
Lordship
that
may
you
dispose
pay
it
this
off.
and.
Yes, yes.
Criminal.
1 second. Where?
21.
Rule 21. Hmm?
21(3) maybe.
You have this?
Lordship, I have, but Lordship, in criminal case,
Let us. Why, Miss Seal? Why are you getting so anxious? Let us first understand. They have raised an objection. This court has to consider the objection. Do you have a copy of the rule?
Lordship, I have knowledge of it.
You have knowledge.
I know that the rule.
Knowing is not
Book,
good.
I don't have.
As counsel, you're expected to have the relevant books when you're arguing a matter, and especially when when you seek upgradation of a matter. You must be carrying all the relevant books. Asan, you have a copy. You have a copy of this, Mr. Nayak? But this talks about departmental proceeding.
No,
Where?
Lordship, criminal proceeding is
Where-
also
where-
there
where
in
is it
3.
there?
3, Lordship, 21(3).
3.
Yes, Lordship.
21 has A, B,
C.
Then C. No such judicial proceedings if not instituted. If not instituted while the officer was in service, whether before his retirement or during his re-employment, shall be instituted in respect of a cause of action which arose or an event which took place before 4 years. What does this mean? Of withholding or withdrawing a pension if in a departmental or judicial proceeding is found guilty. But he's not found guilty. How will Rule 21 come? Your
No,
departmental...
Lordship, if he found guilty, Lordship,
Yes,
then
but there is, you see, Ms. Bhattacharya, you have
Lordship.
to understand that the departmental proceedings has been dropped. Just because some criminal case is pending,
Lordship.
can you by citing 21 withheld the entitlements? Because the criminal court has not returned a verdict.
But charges has been framed against him, Lordship.
Yes,
This
but,
is their Lordship.
But if you come to 21,
allow
it
me
says
some
is
time,
found
Lordship.
guilty.
Lordship.
I will allow you time. You can have a look at it.
No, I have a judgment of a coordinating, very recent
Very well.
judgment, Lordship. Lordship, that's what I'm just finding it out. Well, one of the coordinating benches observed that yes, he is entitled for all this, but including the provisional pension, but DCRG and the regular pension.
Give me
to be,
that.
yes, Lordship. I'm just.
All right, I'll take it up in some time.
Yes, Lordship.
I'll, in the meantime, call the next matter. After that, I'll take it up.
Lordship, Lordship.
In criminal case, Lordship, charge sheet has not been filed till date.
All right. Let us see what is that. So far, the court is with you, Miss Sil. As of now, it is apparent 21 talks about only guilty. the criminal court has not returned a verdict. So till now you're not guilty. You'll be assumed to be innocent, presumed to be innocent, isn't it? I'm with you as of now, but let's see.
Lordship.
Yes.
I'm appearing for my senior, Your Lordship. If the matter can be timing for a while, my senior is on his way. Or maybe preferably at the end of the list, if Your Lordship so.
Well, that actually there is a hearing matter which is fixed at 2 also, which will take time. You have it on Tuesday.
Or for the time being, if Your Lordship so permits.
Tuesday?
Before
28. Yes, yes.
After vacation, my senior, Mr. A.K. Sahibala will be not available the next week.
You are Mr.
D. Goswami.
As prayed for by Mr. D. Goswami, Learned Counsel appearing on behalf of
Mr. A.K. Sahibala.
Mr. A.K. Sahibala. List this matter.
I'll leave it to Your Lordship, but immediately after opening, because the
Give
client
a
has
date.
some urgent-
Give a date on such and such date. On the ground that Mr. Sahibala
On 22nd of
is not
October, Your Lordship.
available in the next week. Is not available.
On 22nd of October, that's
On
a
20.
Tuesday.
Make register. Lordship, may take up 31, serial number 31.
31.
Lordship,
Yes.
it pertains to dismissal from service. Lordship.
Yes.
The first show cause notice is at page 43.
Page?
43.
Yes.
Second paragraph, Lordship. While you were posted at Jirighat PS on the night of 21/22/2023, you were detailed for Naka checking duty at NH Way 37, Assam Manipur, in front of Jirighat PS, along with UBC 289 Rakesh Sinha, UBC 348 Bahar Ahmed Loskar. During your duty period, 5 numbers of container trucks with registration number so and so were allowed to enter into the state from the neighboring state without proper checking and making necessary entries in the Naka checking register. And last paragraph, your above acts tantamount to gross misconduct, dereliction of duty, and unbecoming act of
It
member
looks
of
like
discipline.
you have already assumed that he is guilty.
Yes.
Mr. Goswami, have you seen the tone and tenor of the first show cause notice as to why any of the penalties prescribed therein should not be inflicted? That means you have already presumed and assumed that he is guilty, and now it is only the question of imposing penalty. It appears that it is not with an open and a fair mind that the first show cause notice has been issued. Is this your ground? Is this one of your ground or?
No,
That is
no,
the so-called notice.
no, Lordship, no ground.
That is the so-called
On that point, they had not taken
They
any
have not
ground.
taken
Yes.
a ground. All right.
That page 45 is the statement of allegation, Lordship.
Page?
45.
All right, Mr. Goswami, I'll come back to you.
Lordship.
45.
Yes, sir.
Yes, please read.
While AC Rupkumar Das was posted in Jirighat so and so, Rupkumar Das was detailed for Naka checking duty, Assam Manipur, in front of Jirighat PS, along with UBC 289 Rakesh Sinha and UBC T48 Bahar Ahmed Loskar. During your duty period, 5 numbers of container trucks with registration number so and so were allowed to enter into the state for neighboring state without proper checking and making necessary entries in the Naka checking register. Later on, 5 numbers of container trucks were intercepted at Gumrah PIC, and on checking, all the container trucks were found loaded with suspected to be Erakanat. Subsequently, SI so and so, Lordship may come to last paragraph, Lordship. These are the detail of the.
What you are HC Rup Kumar Das.
Yes, Lordship.
You were posted at the Jirighat PS.
Yes, sir. Naka checking duty, I was allotted to it. And then the Lordship may come to reply, Lordship. Page 47, Lordship.
Yes.
Page 48 is the relevant replies, Lordship. First paragraph. That
Yes.
on 21/4/2023, the said constable and helper took dinner one after another at 9 p.m. And after that, I took my dinner at about 9:30 p.m. and back on duty spot on 10 p.m., wherein all the constables were present in the duty, including me. That said, during the duty hours, as about 10:30 p.m., I suddenly felt tired and illness, and so took rest on the charpai, laying near the gate ghar, and soon fell asleep. Before going to rest, I asked EBC Rakesh Sinha to make necessary entry of all the vehicles, and also asked Bahardin to check all the vehicles, make necessary entry in the register. Sri Manojnath, a local boy, was also
Mr.
in
Counsel, what are the grounds? Because you see, I have a very limited jurisdiction as far as disciplinary proceedings are concerned. I'm not exercising the power of an appeal. I'm only concerned with the decision-making process, right? So what is the ground that you are trying to draw home? Please, just I'll go into it in details, but just to indicate what is the ground.
They have taken the decision of dismissal from service. It would have been reduced to some other punishment.
So you are basically on proportionate.
Proportionate.
According to you, the penalty imposed is not proportionate with the gravity of the charge. Well, this charge appears to be grave. It appears to be grave. How can you say? If that is the only, that means you are at this stage, you are not challenging the findings of the inquiry authorities. You are accepting it. All you are saying is that it is not proportionate, but the principle of that is well settled. It is only when it shocks the conscience of the court, then and then only this court shall interfere with the quantum of the punishment, not otherwise.
Very clear.
Charges are grave. Are you carrying that authority? What is why this new culture has evolved in this court where counsels appear in hearing matters without even carrying the basic case laws involved in the subject matter of that particular petition?
Case laws are there.
You have proportionate.
Yes, sir.
Yeah.
Paragraph 18 and 26.
Paragraph?
Paragraph 18 and 26.
18.
Yes, sir.
Where about the punishment? $22.
Yes, sir.
You see? 22. Subpara 1. To judge the validity of any administrative order or statutory discretion, normally the Wednesbury test is to be applied to find out if the decision was illegal or suffered from procedural improprieties or was one which no sensible decision maker could, on the material before him and within the framework of the law, have arrived at. Correct? This is what I was saying. Now, in your case, the decision, the charges which has been proved in the inquiry appears to be of grave. Yes, where is the, are these listed charges? Is there anything in the rules? Mr. Goswami, the rules provides anything?
Regarding the
Punishment?
regarding the punishment is a misconduct, Lordship. Therefore, major punishment may be imposed, Lordship.
Is there any, which rule is
Yes,
applicable?
rule is-
Just point out and place the relevant rules, Mr. Goswami.
yes.
Yes. Which rule is applicable? Misconduct under which rule? Assam Police Manual
No,
Part 3 Rule 66 2A
Yes.
and then Rule 7. Yes. Rule 7 also of Assam Discipline and Appeal Rules.
Appeal rules, Lordship. The major punishment is there.
This court has to do all the homework, looks like. Yes. এখন দিয়কচোন আছে নেকি?
Yes,
Assam
Lordship, it is
Police
Assam
Manual
Police Manual 66
Part
2,
3
Lordship.
এখন আছে। Police Manual 9. Assam Services Discipline and Appeal Rules to Assam.
And Lordship, section 65 of Assam Police.
You have a copy of that rule, the manual, Assam Police Manual.
Assam Police Manual,
Where are you reading from?
It is from Lordship. It is the
71.
yes, Lordship, page
Yes,
70.
that I have, but I want to see the contents. Ekon family, Assam Police Manual, Part 3 আছে, huh? Rule 7 of the, yes. The following penalties may for good and sufficient reason and as hereunder provided be imposed on a government servant, namely, here it is a dismissal from service.
Yes,
Yes, Lordship.
Number 7. Mr. Bora, right? Sorry, Mr. Bora. But charges vague. It doesn't shock the conscience of this court
That is correct,
so as to interfere with the quantum. The authorities have taken a call.
Lordship, may allow me some time to satisfy the court.
No, what sometime?
In the next week, Lordship.
You cannot change the basic facts of the case. These are the facts. Where was the where is the inquiry report?
Page
Page
54, Lordship.
50?
54.
4.
Annexure 10.
All right. We'll take 31 to the mark code division. Rule 66 to A. Part 3 to sir. Mark code, yeah. 31 to Lobo first. Heard Mr. M.K. Bora, learned counsel for the petitioner. Stop. Also heard Mr. J.K. Goswami, learned additional senior government advocate for the state respondent.
State respondent. All the respondents.
There were 3 persons.
3 persons. Yes.
Can you ask your junior to give me the details of the 3 persons? Only the details, because that perhaps is the only difference. Otherwise, everything will remain same. The designation and if anything, any particular details which distinguish them from the other 2. Okay. By way of this petition under Article 2 to 6 of the Constitution of India, the petitioners are challenging the orders dated 7/7/2023 and 27/9/2023, whereby the petitioners were dismissed from service. The facts of the case is that the 3 petitioners were working as head constable. Yes, that the petitioners, pursuant to a valid recruitment process, were appointed by the armed branch constable, and thereafter the petitioners were working as head constable under the respondents. Stop. It is the specific case of the petitioners that while they were posted as head constable at Jirighat police station in the district of Kachar, Assam, and were allotted to Naka duty on 21/4/2023, at Jirighat Naka post. The petitioner, when had taken a little break from their duties, an incident happened for which they were dismissed, for which an inquiry was constituted, and after conclusion of the same, they were dismissed from service. Stop. Accordingly, the present writ petition has been preferred. Petitions have been preferred. Mr. Bora, learned counsel for the petitioner, submits that the punishment imposed within quotes dismissal from service by the disciplinary authorities is not proportionate to the gravement of the offense proved, and as such contends that the punishment be altered and reduced.
Yes.
Stop. Per contra, Mr. J.K. Goswami, learned counsel, additional senior government advocate for the state respondent submits that the gravamen of the offense does not warrant any alteration of the quantum of the punishment, quantum of the penalty imposed by the disciplinary authorities by this court while exercising jurisdiction under Article 226 of the Constitution of India. Stop. He further relies on Rule 26, on Rule 66 of the Assam Police Manual Part 3 to contend that the charges being that of contents that it is rule 2 কৈছো তুমি তাৰ আগত কৈ দিবা that penalty was awarded in terms of Rule 66 part 3 of the Assam Police Manual, read with Rule 7 of the Assam Services within bracket Discipline and Appeal Rules 1964, and as such warrants no interference from this honorable court. I have given prudent consideration to the arguments made by both parties and have perused the materials available on record. Rupak, good to read. Since Mr. Mbora, learned counsel for the petitioner, has raised the issue, had argued only as regards the quantum of the punishment penalty imposed by the disciplinary authorities, comma, the only issue that falls for determination in these writ petition is as to whether the penalty imposed by the disciplinary proceeding is proportionate to the gravamen of the charges leveled. It appears that the petitioners, while posted at Jirighat PS on the night of 21/22/2023 at the Naka duty at NH Way 37 Assam-Manipur, comma, 5 numbers of container trucks were allowed to enter into the state from the neighboring state without proper checking and making necessary entries in the Naka checking register. And later on, these 5 numbers of container trucks being intercepted at Gumra PIC, and upon checking, Erica nut were seized from the said containers. Accordingly, show cause notice. Is the show cause notice date same in all the three petitioners' cases? Because what happens, Mr. Bora, when it's a series, it becomes very difficult if the dates are different. Show cause notices were issued to the petitioners on 8/5/2023.
Yes, Lordship. Dates are same.
Informing that for showing cause as giving an opportunity to the petitioners to submit their written statement in defense. Stop. The statement of allegations contained in the show cause notice is reproduced hereunder for ready reference. Page number 45, A to A. It appears that thereafter, a departmental proceeding was initiated wherein the inquiry officer, after examining the prosecution witnesses and recording their statement in the presence of the alleged charge officer, and upon giving all opportunity to the charged officers, came to the findings that the containers carrying illegal Burmese Erica nut, which were coming from Manipur, were allowed to be entered into Assam through Jirighat Naka Point for the malified intention of charged officers I.H.C. Roop Kumar Das, within bracket, writ petitioner in WPC 6229 of 2023, along with UBC/289 Rakesh Singha, within bracket, petitioner in WPC 6228 of 23, and UBC 348 Bahar Ahmed Laskar, within bracket, petitioner in WPC 6185 2023. And accordingly came to the conclusion that the said charged officers has failed to do their assigned duties sincerely and honestly, and accordingly the charges of gross misconduct and dereliction of duty as brought against them stands proved. Mr. Bora, here they are talking about only H.C. Roop Kumar Das.
Yes, sir.
So there are three different inquiry reports.
Yes.
Mr. Goswami, there are three different,
Yes.
correct? So what I have dictated is correct? Any changes you want?
No.
It It is correct, right? Stop. Pursuant to which the copy of the inquiry report was served upon the petitioners by way of second show cause notice dated 23/6/2023, providing opportunity to the petitioners to place their providing an opportunity. It appears that the petitioners it appears that thereafter the petitioners filed reply and after the same was considered, the disciplinary authorities by order dated 7/7/2023 was pleased to award the penalty within bracket dismissal from service with effect from 7/7/2023 as per Assam Police Manual Part 3 Roman 3 Rule 66 within bracket 2 within bracket small a rule and read with Rule 7 of the Assam Services within bracket Discipline and Appeal Rules 1964 and read with Section 65 of the Assam Police Act 2007 against the petitioners. The scope of this court under Article 226 of the Constitution of India, while examining the validity and legality of the disciplinary proceedings, is limited and is only confined to the decision-making process. It appears that in the instant case, the learned counsel appearing for the petitioners has not argued that the inquiry held suffers from any procedural illegality or irregularity, and the only point argued is that the penalty of dismissal from service awarded to them is not proportionate to the gravamen of the charges leveled. Charges proved. Ordinarily, this court, while exercising jurisdiction under Article 226 of the Constitution of India, shall not interfere with the penalty awarded unless and until it shocks the conscience of the court. Stop. In other words, the test of Wednesbury requires to be satisfied. It is only when the punishment awarded appears to be in outrageous defiance of logic and shocking, this court may, in a given set of facts and circumstances of a case, interfere with the punishment so awarded. Stop. Reference is made to the decision of the Apex Court in the case of Chairman cum Managing Director, Coal India Limited and others versus Mukul Kumar Chaudhary, reported in 2009, volume 15, SSC 620. Paragraph 22. Yet my green to green flag visual. Paragraph 22 to 26 of the aforesaid decision is reproduced here under for ready reference. A to A. A citation to A to Belek to kind of comment here about the silo. Applying the aforesaid principles of law to the context of the present case, it appears that the charges proved against the petitioners are grave and therefore this court finds no illegality or infirmity in the penalty imposed by the disciplinary authorities. As such, this writ petition fails. Accordingly, the writ petition stands dismissed, no cost. Sorry. এটা তিনটা disposal.
My lord, in item number 29, my name may be recorded. Item number 29, my lord.
29, you are the petitioner?
Yes, my lord.
Acha, 29 at Lulu. Yes, you found that
Yes,
decision?
Lordship, I have already emailed. And also a notification of the Pension and Public Grievance Department,
Just
Lordship.
Good job. এইটো মোৰ টেবুলত থৈ দিবা দৰকাৰ হ'লে কিটা আপলোড কৰি দিম টেবুলত থৈ দিম yes এইটো decision দিম what is this notification
Is of there is a notification of the ES Lordship granting of pension and other benefits and also withholding of DCRG Lordship. This is a notification.
The governor is pleased to order that henceforth all so and so shall issue provisional pension and so to all retired so and so after the retirement till final PPO. Final PPO means
That means the final pension paper document.
is issued. It is clarified against whom any departmental or judicial proceeding is continued. No DCI shall be paid to him until the conclusion of such proceeding. That means provisional he will get.
Lordship.
And in this decision, which is the paragraph?
Lordship, 10, 11, 12, it has been discussed, Lordship. And the fact is little different, Lordship. Here, the criminal proceeding, he was charge sheeted, but they have taken a stay by filing an SLP there. So this was pending, but they are claiming that they were getting, the petitioner was getting the provisional pension, but he prayed for release of DCRG as well as the full pension, Lordship. So this has been denied by the court.
This is the notification that is referred here.
Yes, Lordship, this has been referred,
Yes.
Lordship. This is referred in paragraph 11,
11, I
Lordship.
just
Yes,
read.
Lordship. Paragraph 16, Lordship, this has been discussed,
Just
Lordship.
coming. Just finished 15.
Lordship.
In the present case, admittedly, the criminal proceeding is pending.
Yes, Lordship, charges has not been framed, charge sheet has not been given till
But
date.
this notification says that it is clarified that retired so and so against too many departmental or judicial is continued.
Lordship.
So you cannot say that there is no criminal proceeding pending.
Criminal proceeding is
Correct.
there. I
So
have
then you are entitled for provisional, as at this moment. So I can, if
In-
you agree, I can dispose it off with the direction that they should release the provisional.
Provisional pension, I'm getting,
You are
Lordship.
getting it.
Yes, Lordship.
Then
I'm praying for
if
Lordship
then
may
following
kindly-
the
Lordship may-
principle laid by the coordinate bench, this writ petition
Lordship
is
may-
entitled to be dismissed.
Lordship, kindly provide me few days time. I will satisfy your Lordship with some judgment.
All right.
In my favor, Lordship.
Let her
Lordship.
be satisfied. But let me record this.
Lordship. And this
M.
copy of notice.
M. Bhattacharjee, learned standing counsel, you are appearing as additional senior government advocate for the for the state respondent, submits a notification dated 21/6/2012 issued by the Commissioner and Secretary to the Government of Assam Pension and Public Grievances Department to contend that in a case where any departmental or judicial proceeding is continuing, no DCRG shall be paid to the applicant until and unless the conclusion of such proceeding is until the conclusion of such proceedings and issue of the final order thereon. Stop. She further places the decision of a coordinate bench of this court in the case of Hitendra Kumar Datta versus State of Assam report in WPC 2570 of 2020 to buttress in support of the aforesaid contention. MS SC Learned Counsel.
Kanungo, Lordship.
Oh, sorry. S. Kanungo, Learned Counsel for the petitioner, seeks how much time? 2 weeks' time to respond to the aforesaid contention made by the learned additional senior government advocate. Stop. Prayer allowed. List after 2 weeks on a date to be fixed by the registry. A copy of the notification dated 21/6/2012 is kept on record and marked as X. You give a copy to
Lordship, I can. Oblige your Lordship.
Scan করে দেবো।
কি ইনস্ট্রাকশন দেবো রেকর্ড তো আনছে না রেকর্ড
In fact, the court master was looking for you when the admission matters were being called, because I think one of your case has been wrongly listed in the admission, in the hearing.
Okay.
I think that is an admission matter.
Yes, yes.
Your matter is simple. Anyway,
Anyway,
we'll call
my
it.
lord, in this case, the facts of this case are, my lord, there was a criminal proceeding initiated against the petitioner. That criminal proceeding ended in favor of the petitioner. Now, on the same set of charge, based on the same evidence, a disciplinary proceeding has been initiated.
There is some decision of the apex court. I
Yes,
think,
yes,
not
it
on
can
this-
be.
Cannot be.
Yes. Now, my lord, what had happened, it appears from the affidavit filed by the respondent that there was an inquiry report submitted by the inquiry officer, and the authority
Mr. Das, you must have all the papers ready for your senior.
No, my lord, in the affidavit file, they have taken a stand that the inquiry report has been submitted and the authority, the appointing authority or the disciplinary authority, they are contemplating to order a fresh inquiry. It is in that context, on the last occasion when the matter was listed, this honorable court was of the view that you can't do that, produce the record. But
Records are
otherwise,
available?
my lord, I can satisfy your lordships.
Records are available?
Yes, Lordship.
Where is the prayer page?
Page 17 onwards.
Page 17. Just let me get a grip of the
If your
matter.
lordship would kindly come to page number 106.
106. This is that reply, the affidavit.
Yes.
Yes.
That with regard to the statement made in paragraph 13 of the writ petition, the deponent begs to state that the departmental proceeding was initiated against Bhupesh Chandra Das by show cause notice dated so-and-so under the provisions of for violation of the rules of the Assam Civil Service Conduct Rules, which was unbecoming of a government servant. The inquiry officer who was appointed by order dated under the provisions of the so-and-so rule has submitted the inquiry report by letter dated 3/9/21. On examination of the inquiry report, disciplinary authority has decided for a further inquiry by recording further evidence, including statement of remaining witnesses, particularly the police officer who are duty bound to give their statement, and also consider the pre-trap, trap, and post-trap memorandum as well as FSL report in the context of the standard of proof required in the departmental proceeding in concurrence with the judicial department. Now, assuming, my lord, for the sake of argument, that this stand of the disciplinary authority is correct. Now, on my first plan, if I succeed, then this will not even come. Now, what is my first plan? When criminal case and disciplinary proceedings are grounded on the same facts, to be proved by the same set of witness, same circumstance, then it is said that disciplinary proceedings should await the outcome of the criminal case. In other words, the first step to be done is the disciplinary proceedings should be interdicted for the present, for the moment. Then, depending upon the outcome of the criminal case, the call would be taken. Now, in Paul Anthony, my lord, Honorable Supreme Court said that if the criminal case ends in favor of the delinquent, then he should be acquitted of all the charges, and if he is found guilty, then the necessary punishment should be imposed. So that is the law.
What happened here?
Now, here, my
Criminal
lord,
case?
as it appears, the inquiry officer has submitted the report. It must be in my favor.
No, the criminal case?
The criminal case ended in my favor.
Oh, it ended in your favor?
Yes, acquittal. Now, my lord, this disciplinary inquiry must be in my favor. That's why they want to make further inquiry. So that will come subsequently. Now, if in the last occasion I have placed the judgment, my lord.
Yes, I have.
If your lordship have Paul Anthony's case.
Anthony, para 22.
Yes. No. My lord will kindly come. Yes, yes, para 22.
Just before that, just 1 second. I
Yes.
want to see the prayer. What is the prayer? Page 18, 17.
Yes, my lord, to quash the proceedings.
This is the second departmental proceeding.
No, my lord.
First.
First. Only one.
No, right now we are in the stage where the inquiry report has been submitted. However, the department, in the inquiry report, it is in your favor.
I am assuming.
You're assuming.
That's why,
Because at the time of considering that inquiry report, the departmental authorities decided to hold
further
inquiries. Correct. At that stage, you have
No, I didn't know, my lord, that in 2001 itself, in September 2021 itself, the inquiry report was submitted. I don't know, because meanwhile, my lord, I've been reinstated in service.
So
I approached this honorable court because by this year, by year end, if my name is not nominated, my lord, then I'll lose my lord IS aspiration.
So, without knowing what is the outcome of the inquiry and what has happened, you have assailed the entire departmental proceeding.
Proceeding on the ground that I have been given a clean sheet in the criminal
After
case.
that means after you have been
Acquitted
after
in the
the
criminal
court returned a verdict in your favor.
Yes.
Okay.
Now please come to my lord, para
Yes.
22 of Paul Anthony.
If what you are saying is correct, then it is an open and shut
case. Kindly see, my lord, para 22.
Yes.
Now please come to Roman 2, my lord. if departmental proceeding and criminal case are based on identical and similar set of facts, and the charge in the criminal case against the delinquent employees of grave nature, which involve complicated question of law and fact, it would be desirable to stay the departmental proceeding till conclusion of the criminal trial. So this is the first in point of time. Now please come to Roman 5. If the criminal case does not proceed or its disposal is being unduly delayed, the departmental proceeding, even if they are stayed on account of pendency of criminal case, can be resumed and proceeded with so as to conclude them at an early date. Now this is important. So that if employee is found not guilty, his honor may be vindicated, and in case he is found guilty, administration may get rid of him at the earliest. So idea of staying the proceeding is to await the outcome of the criminal case. Once the criminal court returns a finding, then based on that finding, consequential order has to be passed.
Yes, please show me that it involves the same.
Yes. Now before that, my lord, I'll place one more judgment.
GM10.
Yes. That is, my lord, what has happened in this case. For the purpose of the facts, if your lordships would kindly come to paragraph 3.
Yes.
Para 3. The appellant joined the service in 1953 as an overseer. The appellant was regularly submitting his property return, showing all his movable and immovable property. As per the department, the movable and immovable property were disproportionate to his known source of income. The Anti-Corruption Bureau carried out an investigation against the appellant and submitted a report, and on the basis of the said report, a charge sheet dated 22/1979 was issued, alleging that the appellant had illegally accumulated the excess income by way of gratification. The appellant submitted his explanation on 15/5/79 and denied the allegation as well as the charges made in the charge sheet. A departmental inquiry was ordered, and as per the departmental inquiry report dated 31/3/80, appellant was found guilty of the charge. Respondent by order dated 21/10/82 passed an order of dismissal from service as punishment. So in this case, my lord, in the departmental proceeding which preceded the criminal case, he was dismissed. Against the said dismissal order, appellant filed a writ petition before the High Court. The learned single judge concluded that there is sufficient evidence against the appellant and dismissed the petition. Against the order of the learned single judge, appellant preferred an LPA and raised the relevant contention. Division bench dismissed the appeal by confirming the order of the learned single judge. Said decision is challenged in this appeal by special leave. So, in the departmental proceeding, my lord, the punishment was affirmed by both single judge and division bench. Now kindly come to paragraph 30. The judgment relied on by the learned counsel appearing for the respondent are distinguishable on facts or on law. In this case, departmental proceeding and criminal case are based on identical similar set of facts, and charge in the departmental case against the appellant and the charge before the criminal court was one and the same. It is true that the nature of charge in the departmental proceeding and in the criminal case is grave. The nature of the case launched against the appellant on the basis of evidence and material collected against him during inquiry and investigation, and as reflected in the charge sheet, factors mentioned are one and the same. In other words, charges, evidence, witness, circumstances are one and the same. In the present case, the criminal and departmental proceedings have already noticed or granted on the same set of facts, namely a raid conducted at the appellant's residence, recovery of articles therefrom. Investigating officers, Sri so-and-so and other departmental witnesses were the only witnesses examined by the inquiry officer, who by relying upon the statement came to the conclusion that the charges were established against the appellant. Same witnesses were examined in the criminal case, and criminal court on examination came to the conclusion that prosecution had not proved the guilt and alleged against the appellant, the allegation against the appellant raised beyond any reasonable doubt and acquitted the appellant by judicial pronouncement with the finding that the charges had not been proved. It is also to be noticed that judicial pronouncement was made after a regular trial and on hot contest. Under these circumstances, it would be unjust, unfair, and rather oppressive to allow findings recorded in the departmental proceedings to stand. In our opinion, such fact and evidence in the disciplinary departmental as well criminal proceedings were same without there being any iota of difference. The appellant should succeed. Now, my lord, this is the law. Now come to the facts.
But this law perhaps has to be understood in the context of each case.
Yes.
Because
It has to be on the same.
It could be also, even if it is the same nature, perhaps in certain cases, you see, because the
correct.
In criminal case,
no, my lord,
reasonable, beyond reasonable doubt.
No, my lord,
But
despite that,
so I think some
no, in Paul Anthony, my lord, that aspect was taken note of in the preceding paragraphs, that in a criminal case, the standard of proof is beyond any reasonable doubt,
and here
but here it is
of
only
probability.
preponderance of probability. Now, my lord will kindly come
which
to
paragraph, Mr. Chaudhary,
Yes.
in Paul Anthony?
Yes,
Because this thing had just come. I'm not saying in the context of your case.
Yes, correct.
It would depend in the context of each case.
Yes. Yes. My lord will kindly come to para 19.
Yes. BK Meena.
Yes. Now, my lord, BK Meena is quoted. If your lordships will kindly come to the last two lines towards the bottom, this ground at page 689, last two sentences, my lord.
Page
689.
This ground.
Yes. This ground has, however, been hedged in by providing further. Thus, this may be done in cases of grave nature involving questions of fact and law. In our respectful opinion, it means that not only the charges must be grave, but that the case must involve complicated questions of law and fact. Moreover, advisability, desirability, or propriety, as the case may be, has to determine in each case taking into consideration all the facts and circumstances of the case. The ground indicated in DCM is also an important invariable rule.
Is also not an invariable.
Not an invariable rule. It is only a factor which will go into the scales while judging the advisability. I'll just find out that paragraph where the discussion on yes, my lord. Huh?
As we shall be
As
we shall presently see.
As we shall presently see. Huh. $19 or
may not be in this case. Even I'm not finding that particular
I
word.
think it is there, my lord. One second. GM Gankot Kole. Sorry. Yeah, take it. So,
I think it is para 31 of the GM10.
Yes.
Para 31. I
In
think.
fact, I'm looking at, no, I think in GM tank, my lord, this was dealt with.
Yes, that's what GM10 31 in
Yes,
our opinion.
in our opinion, such fact and evidence in the departmental criminality were the same without there being any iota of difference, the appellant should succeed.
The
The distinction which is usually proved between a departmental and criminal proceedings on the basis of approach, and this is the line, my lord,
And burden of
and
proof.
burden of proof would not be applicable in the instant case. Though the finding recorded in the domestic inquiry was found to be valid by the courts below,
See, that is why I
when
was
there
saying,
was an honorable acquittal employed during the penal proceeding, the same requires to be taken
perhaps
note
it
of.
would require an appreciation in the context of each case.
Yes,
Whether
Yes.
because of a clean sheet in a
Now,
criminal
now, my
case,
lord,
whether the
now, my lord, you
disciplinary
kindly
authority
see in
is
this
bound.
case, please come to page 39, the charge sheet.
Your case.
Yes.
Page 31.
39.
39.
Part of the charge sheet.
Yes.
Can you see, my lord? Name and address of the witnesses, what point is called to prove. Teher Gaur, Saidur Rahman, then serial number 9, Koruna Bordoloi, serial number 11, Inspector Horisaran Pathak, Inspector Lakshminarayan Burwa. These are the witnesses, my lord. Now kindly come to the allegation at page 40.
The criminal.
In the criminal.
Yes.
The charge of the case is that on
Page,
21, page 40, my lord.
So you are trying to show that the same witnesses.
Exactly same allegation,
Page
same
40.
page 40. The charge of the case is that on 21/9/17, the complainant Sri Teheru Gaur launched an FIR at ACB police station to the effect that on 21/9/17 at 11 a.m., Bhupesh Chandra Das had called one lessee, namely Saidur Rahman, to his official residence and demanded from him a sum of rupees 8 lakhs for allotment of lease of Decimary weekly and daily bazaar in his name. He told Saidur Rahman that he would allot the bazaar to some other person if he paid to him the above noted bribe. Saidur Rahman informed the complainant Teheru Jogor, Jila Parishad member of Lalpul Jila Parishad constituency, about the matter and requested him to take necessary action. So this is the allegation, my lord. Now please come to page number 58, departmental inquiry. Statement of allegation. That on 21/9/17, so-and-so lodged an affair to the effect that on 29/17, Bhupesh Chandra Das, ACS, Dorong, had called one lessee, namely Saidur Rahman, to his official residence and demand from him a sum of rupees 8 lakhs. Same allegation. Now please come to page 59. The same witnesses, same circumstance. So it's an inescapable case, my lord. So therefore, the benefit of GM Tang must follow. This is my case.
At 2, another matter is fixed. Perhaps probably I shall dictate the judgment.
Lordship can keep it for some other day also. In fact, if I have 2 o'clock, division bench will be sitting. I have some matters there also.
Tuesday, but otherwise after that I can make an attempt on this.
Yes.
Since
if I'm free, I'll come. All my junior will be there. I'll come.
Mr. Das,
Yes.
you be here.
Yes, yes.
So after that we will take up this.
Yes,
we will
yes.
not take up other hearing. We'll see. This is that matter which was fixed at 2.
Yes.
You want to give something?
My lord, yesterday I said the citation.
Have you given a copy to Mr. Majumdar?
Majumdar,
Or at least
I'm giving.
for his benefit you give the
Yeah, I'm
citation?
giving. Yes, I'm giving him also.
Yes, which para?
That is, my lord.
This is on proportionality.
Not there is proposal under that under section 11 that awarded that dismissal for service can be awarded on that. Yesterday, day before yesterday, I think.
But which page?
Which para, my lord?
7 or what?
Sorry, my lord. Third, from the last third pillar. From the last portion, third pillar.
Yes.
It may be noted that section 9.
Yes, page 7.
It may be noted that section 9
Yes,
of
para 7 you are reading.
para 7, yes. It may be noted that section 9 of the Act mentions serious and heinous offense and also prescribed penalty which may be awarded for them. Section 10 deals with the less heinous offense and clause M thereof shows that the absence of a member of the force without leave or
How
without
is it relevant?
But it's not relevant.
If I recollect, this is that case, isn't it? That intoxication.
Intoxication, yes. That the honorable court asks that the citation only that under section 11 the dismissal can be granted in section under section 11.
That is already there, I think, in that rule which you have.
Yes, yes, that is
says
there.
that in
Yes.
lieu of dismissal, anything else can be
Yes.
given.
That is
Dismissal
there.
can be given. On the proportionality part, it also permits.
I think, yes.
Proportionality part, my lord, I had a three judgments.
What was that relevant rule that you have?
Rule 11.
11.
Yeah, Central is a police force. rules.
CRPS 11.
Let me just take note of that.
Lordship would have 10 first.
First.
Rule 10.
Rule 10.
A relates to intoxication
Yes.
when on or being
Yes.
warned for duty.
Uh,
Then my learned friend relied upon 10N.
Yes.
Guilty of any act or omission
Yes.
which, though not specified, is prejudicial to
This
good order.
was relied by Ms. Gayan to
Yes.
show that it envisaged any other
Yes, which is
act
not in
which is
list
not
of
listed,
Yes, yes, ma'am.
but subject to the condition that it is
Prejudice.
prejudicial.
Yes, ma'am.
Yes.
The judgments that I have just given. And
So from the rules, it is only 10, no?
10.
And 11 is the minor
Punishment.
punishments.
and
And
27
27 is the rule.
27
Rule 27.
is the procedure.
Procedure.
procedure and the punishment. The recent judgment of the Supreme Court is there that any of the punishments of 27 can also be given.
Yes, wanted to
There are
show
the three
something.
judgments that I had given. The first one is 2013 6 SCC 602.
2000?
13 6 SCC 602. I have underlined a bit of. There, Lordship may like to have paragraph 18.
Paragraph 18. This is on
The quantum of punishment. All the three on quantum of punishment only, today I have given. The question of interference on the quantum of punishment, as has been considered by this court in a katana of judgments, and it was held that if the punishment awarded is disproportionate to the gravity of the misconduct, it would be arbitrary and thus violate the mandate of Article 14 of the Constitution. In Ranjit Thakur versus so-and-so, the sentence has to suit the offense and the offender. It would be vindictive. It should not be vindictive or unduly harsh. It should not be so disproportionate to shock the conscience of the court. That is one part. In the next judgment, my lord, 2013 11 SCC 187.
Yes.
There, Lordship will find that para 9.
No, no, you did not need read it.
And the last judgment of the Guwahati High Court, where in a similar situation, a CISF personnel was found to be drunk when he got the notice that his mother was not keeping well, and he was not on duty. He was inside the campus but not on duty. This honorable court held that termination is too harsh.
But otherwise, that is a listed offense.
No, that was not discussed. Only what was discussed was that he was inside
But
the
this
campus.
this is concerning the CISF Act.
CISF.
CISF
The same
Act.
parameter, but since they said
No, I'm not on that. You see, Mr. Majumdar, for this court, the first thing that this court is considering is that the offense with which you have been charged is not listed if one wants to act under N, the condition precedent of prejudicial
Discipline.
to the discipline and good order has to be there. Now you have already been acquitted. Now once you have acquitted, nothing remains. How can that be? There is that decision. Did you give that decision about the criminal? I think
Yes, in the additional affidavit, I have given the.
correct. No, but there is a decision of that effect. I think Mr. K.N. Chaudhary today had yes, that Paul Anthony.
And Paul Anthony, yes. That was
So-
more of the criminal and the.
No, that is if you are acquitted in the criminal trial.
Madam.
So that if the employee is found not guilty, his honor may be vindicated. So you have already been.
That may be observed at the time of proceeding. That was.
That's all right.
that
But
may be
now it has
observed.
come.
Yes.
You see, because
Yes.
if you even for some reason you want to say that yes, he acted in a manner
Yes,
which
madam.
would cause prejudice to.
Yes, madam.
Correct.
Yes.
For that you are relying on
It
the
is
incident
conduct. Yes,
that has happened on the basis with which a criminal trial was held.
Yes, madam.
But there, it has been returned.
Acquitted. Yes.
The verdict has been given in his favor. So that goes. So if that goes, there is nothing for you to say that to act under that that subsection N.
In fact, my lord, the case which I had faced, the trial which I had faced, that did not contain the allegation of intoxication and doing something. That part was not there. The Railways Protection, the Railway Act says that anybody found intoxicated has to be tried for it. There was no allegation in the charge sheet.
In which case?
In the criminal case that I had faced, the only allegation was I pushed someone out, and that was negated. So even there, although they had a medical, they tried to show a medical document or the statement of the GRT officer.
No, but even in this case, mere intoxication is not a crime.
No.
Under the listed offense, if you are on duty, yes. If you are marching, yes. Correct?
Yes.
If I remember correctly,
Yes,
I
yes.
have not opened the brief.
Yes, yes, sir.
So correct me if I'm wrong.
It's true.
And under N, it says any act.
Any act.
But
Subject to prejudice.
so if you were found, if you were in a state of intoxication, and if those allegations would have been proved,
Then it was
then of course,
because I carried the
yes,
seal of the.
then the subsequent question would come whether it is proportionate or not proportionate.
Yes.
But here,
Nothing.
if this court is ultimately going to, if the court comes to a finding that there is no offense, then nothing survives. Then why should this court go into the quantum?
Then not necessary.
Then it will not be necessary because you have challenged the entire
Yes.
disciplinary proceeding, isn't
Yes,
it?
yes.
The inquiry is under challenge here, isn't
Yes,
it?
everything is under.
Face prayer. Yes, impugn inquiry report.
Yes.
So if I quash the inquiry report, nothing goes. I am still not sure what to do, but I am just indicating because it appears that the two allegations which was leveled against you are not listed offense, listed misconduct, right? Ms. Gayan, you had submitted few judgments the other day.
Yes,
Let
sir.
me
One
just,
judgment I have submitted regarding 11 and
one
another is
second, one
regarding
second.
226.
So, Mr. Majumdar, along with these two, you had also given that Mirat case, right?
Yes.
Mirat was given by you and
Yes.
the Rajasthan High Court,
Yes. Yes.
Sunil Kumar.
Yes. Ma'am.
So,
Sunil
you
Kumar.
have given 4 cases.
Yes.
And Ms. Gayan, you had given Ghulam Muhammad
Ghulam Muhammad and Mukesh Kumar Raigar.
and which one?
Mukesh Kumar
Mukesh
Raigar.
Kumar Raigar.
Yes.
And also one case you had given, I think.
That is my citation. Today I have given the citation. That is not in the citation. That is
No,
I
these
think-
two cases that.
These are similar,
huh?
my lord.
Similar.
Yes, my lord.
Ghulam Muhammad. Oh, acha, acha,
Yes,
acha.
Ghulam Muhammad says that.
All right. So
Under
now,
11
basically, you have substituted it with the SSC.
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 online, yes.
All right. Thank you. In fact, this court was looking for the SSC citation.
Yes, that's right.
I find it very difficult to read from some other
Yeah, that's
journals. SSC is something which is very easy. I don't know about you both, but
Yes, ma'am.
all right, I'll make an attempt right now. Take your seat. In case any corrections required or any in the facts, just
I'll note it.
keep a note
Yes,
At the end.
at the end. You may.
Yes.
Heard Mr. R. Majumdar, learned counsel for the petitioner. Stop. Also heard Mrs. A. Gayan, learned CGC, appearing for all the respondents.
Just point out, Madam, under the synopsis is the list of dates with all the dates. That will be
Where under the?
just under the synopsis. Before the repetition starts is a list of dates.
All right. What was that? Okay.
Mobile rental.
By way of this petition under Article 226 of the Constitution of India, comma, the petitioner is assailing the inquiry report dated 2/3/2015 and the order dated 30/3/2014 passed by the Commandant 48 Battalion Central Reserve Force, a Reserve Police Force, by which the petitioner had been removed from service. Stop. The facts of the case are as follows. The petitioner joined the services of the Central Reserve Police Force as a constable stroke general duty in the year 2011. And he had availed 30 days earned leave from 26/2014 to 27/2014. Stop. It is the specific case of the petitioner that the petitioner applied for extension of leave, or extension of his leave on medical ground, and that on 24/7/2014, he was informed that the said request has been rejected. Accordingly, on 26/7/2014, the petitioner proceeded to Dhubri to join his duty by traveling in the Northeast Express train. However, while he was traveling in the said train on 27/7/2014, the Government Railway Police Fatehpur arrested him along with another person on the basis of an FIR lodged by a co-passenger to the effect that the petitioner and the other person had scuffled with the brother of the informant. Stop. It is a specific case of the petitioner that the office of the GRP police station Fatehpur accordingly informed the office of the respondents on 28/7/2014 about his arrest. After which, whereafter the respondents by order dated 8/8/2014 placed the petitioner under deemed suspension with effect from 27/7/2014. It is the further case of the petitioner that after the petitioner reported back to his unit on 13/8/2014 on being released on bail, the said suspension order dated 26/8/2000, the deemed suspension order was revoked by an order dated 26/8/2014. It is the further case of the petitioner that pursuant to an inquiry constituted, and the inquiry officer having submitted its report on 2/2/2015, the petitioner by an order dated 30/3/2015 was removed from service with effect from 30/3/2015. Situated thus, the present writ petition has been filed. Mr. Majumdar submits that the charged offense, the alleged charged offense, are not listed offenses, and as such, no case of misconduct whatsoever can be said to have been made out against the petitioner. He further submits that assuming but not admitting that the charges have been proved against the petitioner, the penalty of removal from service within courts is not proportionate to the gravamen of the charges, and therefore the same warrants alteration from this court. Correct? These are the two submissions of yours. In support of the aforesaid submissions, he relies upon the following decisions of the apex court. First, Messrs. Glaxo Laboratories versus so and so reported in 1984, volume 1, SSE 1. SR Tiwari versus Union of India, reported in 2013, volume 6, SSE 602. Jay Bhagwan versus Commissioner of Police, reported in 2013, 11 SSC 187. He further relies upon the decision of the Rajasthan High Court in the case of Constable Sunil Kumar versus Union of India, reported in 2017, Legal Eagle within bracket RAJ at page 743. Next one. Per contra, MSA Gayan, learned CGC submits vehemently opposing the petition, submits that the offenses that submits that the charges leveled against the petitioner has been duly established and proved before the inquiry officer, and the same being less heinous offenses in terms of section 10 of the Central Reserve Police Force Act 1949, the punishment prescribed under section 11 of the said act, which includes removal from service, comma, the impugned inquiry and punishment warrants no interference from this court. In support of the aforesaid submissions, she relies upon the decisions of the apex court in the case of Union of India and others versus Ghulam Muhammad Bhatt, reported in 2005 volume 13 SSC at page 228, and ex-constable so-and-so versus Union of India, reported in 2023 volume 11 SSC at page 159. She further submits that the power of judicial review under Article 226 of the Constitution of India is limited, and this court, while exercising such powers, is not an appellate court, but reviews the manner in which the decision is made. Stop. Anything else? This was. I have given my prudent consideration to the arguments made by the learned counsels for the parties and have perused the material available on records, including the citations cited at the bar. Apt to refer to the APT, apt to refer to the provisions of the said Act 1949 before entering into the merit of the matter. Section 9 and Section 10 defines more heinous offenses and less heinous offenses. Mr. Majumdar, Ms. Gayan, apart from minor punishment, is there anything saying major punishment? No.
The major,
There is no
the Supreme
specific.
Court in the Gulam Bhat cases said that the dismissal and others can be.
No,
given
what I'm saying is that 11 starts with minor punishment.
Yes.
So that is the only.
That is the only, there is no heading for measure.
And section 11 of the said act prescribes the punishments to be awarded when one is found guilty of disobedience, neglect of duty, or remissionist in the discharge of any duty, or of other misconduct in his capacity as a member of the force. Section 10 is reproduced hereunder for ready reference. Section 11 is also reproduced hereunder for ready reference. Yes, what is the decision you just mentioned, Mr. Majumdar? You said it has distinguished about major, minor, something.
No, Gulam Muhammad Bhatt judgment which has been given, in that judgment itself, the Honorable Supreme Court has held that under Section 11, the punishments of dismissal, removal, or compulsory retirement can be given. Although it starts with the heading minor punishments, it only deals with what can be given in lieu of. It does not bar the punishments of dismissal, removal.
So it can be given in the case of less heinous.
Yes.
That is what the Supreme Court says.
Because even this indicates.
Yes.
You see, Section 11
Yes.
says it does not distinguish major, minor,
Yes,
nothing.
but it is
It simply says
There
in
is
lieu
nothing
of.
specific.
There is
like
nothing
you-
specific.
Award in lieu of. So the lieu of was what the Supreme Court emphasized on to say that in lieu of a major punishment, a minor punishment can be given. When the argument was made in this honorable court only, that
I think it's not necessary to go into this.
that would not be necessary.
In the present case, it appears that the petitioner was charged as under. That article number 1 and article number 2, isn't it?
Two articles.
Page 19, A to A. Article number 1 or article number 2. Apparent that the petitioner was firstly charged for being found in a state of intoxication at the Fatehpur railway station / public place as suggested by the FIR and medical documents. Stop. Secondly, for not informing the department as regards his arrest in connection with the aforesaid FIR. Stop. The inquiry officer, after conducting an inquiry, found the aforesaid two charges proved and accordingly submitted its report by order dated 30 March 2015. Stop. Paragraph 7 of the aforesaid report is also reproduced hereunder for ready reference. Page 52 B to B. Huh? Thereafter, where is that decision, that removal order, page
Number
49.
that is 40? No, removal order
Removal order is page 49, madam.
49.
Yes.
Thereafter, the departmental authorities by order dated 30/3/2015. This is not the inquiry report.
No, madam. Inquiry report is at page 19.
So I think I have made a
No,
mistake.
that date is wrong. I have noted it down. I correct the date. It's 15.
Inquiry is where?
15. That is page 19, madam.
Page
19, 19.
19.
And the findings should be at page 29.
Inquiry report dated
15/3.
15/3.
2015.
2015.
I'm sorry, 2/15.
2/15.
Second
2/15. এইটো কি বুলি লিখিলা এই যে ওপৰ পেৰাগ্ৰাফটো ক'লো এটা যে ৰিপ্ৰডিউচ বুলি কৈছা সেইটো আচলতে নেক্সটতহে আহিব, নট ইন দি ইনকুৱাৰী ৰিপৰ্ট। বুজি পালা? মই যে মাত্ৰ ক'লো B2B, সেইটো actually disciplinary authority order. So thereafter, the disciplinary authorities by an order dated 31st something. Where is it said removed from service? This
That lordship will find it page 53.
I punish.
Yes.
They awarded the penalty of removal from the roles of subject battalion with effect from 30/3/2015 against the petitioner. Etia he paragraph 2. Paragraph 7(2). But it don't like a paragraph. No need. You don't have to say it. It appears that as regards the first charge, it appears that the petitioner was charged for being in a state of intoxication at the railway station, which is a public place, as per the allegation contained in the FIR. Stop. Pertinent that the allegation contained, where do I find the allegations of the FIR? Pertinent that the allegation contained in the said FIR was to the effect that the petitioner, along with the co-accused had assaulted the brother of the informant. Correct? If it is correct, I'll stop it there. Stop. A perusal of section 10 indicates that it is only when one is found in a state of intoxication when on or after having been warned for, comma, any duty or on parade or on the line of march, the same constitutes less heinous offense. Admittedly, the petitioner was on leave. And was in a public place. As regards the allegation contained in the FIR, pertinent that during the pendency of this writ petition, the criminal trial the criminal court by the judgment, the trial court by judgment and order dated 11/7/2016 acquitted the petitioner from the charges framed against him under section 308/34/504 IPC. Thus, thus the allegation leveled in the FIR in question does not exist, and as such no offense whatsoever in this disciplinary in the subject disciplinary proceeding in terms of the said FIR can be said to be existing. Stop. Further, I think I don't have to go into the intoxication part because your FIR doesn't say because you're intoxicated, but intoxicated as suggested in the FIR. So they are referring to the marpit.
Marpit and intoxication also in FIR, my lord.
Okay. Further to the fact that the petitioner was in a state of intoxication when he was found in the Fatehpur, right? Fatehpur railway station, comma. Though subsection N of section 10 says that a member of the force who is guilty of any act or omission which, though not specified in this act, is prejudicial to good order and discipline, is said to be a less heinous offense, shall also constitute a less heinous offense. Stop. In order, this court is of the view that in order for an offense to be constituting less heinous offense under subsection N of section 10, it should be of such a nature that it is prejudicial to good order and discipline. Merely because the petitioner was in an intoxication state while he was on leave cannot, in the opinion of this court, be covered under subsection N of section 10 unless and until he does some act, unless and until he does some act in the state of intoxication which shall be prejudicial to good order and discipline. As such, the Article 1 is not made out. Secondly, this takes me to the second charge, which is not informing the respondent as regards his arrest by the GRP Fatehpur pursuant to the subject FIR within bracket case number 38 of 2014. It appears that this is not a listed offense. Though MSA Gayan tried to convince this court that the same shall fall under subsection N of section 10, comma, this court finds difficult to accept the same inasmuch as in order for an act to constitute an offense not listed in terms of subsection N of section 10, it has to be shown that the said act has caused prejudice to the good order and discipline. It further appears that the petitioner during the inquiry has produced evidence where the GRP Fatehpur has informed in writing that they had informed the respondent about the arrest of the accused stroke petitioner by asking the phone number of the control room of 48 Battalion from the petitioner. Stop. That being so, no offense whatsoever can be said to be made out under article number 2 also. Undoubtedly, the powers and ambit of this court under Article 2 to 6 of the Constitution of India, while examining the legality and validity of the disciplinary inquiry, is limited and is only testing the manner in which the decision was made. It is well settled that power of judicial review is meant to ensure that the individual receives fair treatment and not to ensure that the conclusion which the authority reaches is necessarily correct in the eye of the court. Thus, when an inquiry is conducted on the charges of misconduct by a public servant, the court or tribunal would be concerned only to the extent of determining whether the inquiry was held by a competent officer or whether the rules of natural justice and statutory rules were complied with. Stop. Reference is made to the decision of the Apex Court in the case of Mukesh Kumar Raigar, Supra, wherein the Apex Court had clearly held where clearly held her jagah. Reference is made to so and so. Stop. Paragraph
9.
Paragraph 9.
Paragraph 10. 1 0.
9 is required.
9 is not required.
Yes,
Only
paragraph 10. Paragraph 10. I think 11 is the main.
11 is the main, yes, ma'am. That is the quantum of punishment. 10 is the regarding 226 power and 11 is the quantum of fine.
10 doesn't talk about 226, Ms. Gayan. You're referring from the same SSC citation.
Yes, then that is my not that is Mukesh Kumar Raigar.
Yes,
That
yes.
is SSC report.
10 doesn't talk about
11 talk about.
11. I think
11,
it will
yes.
start from 11.
Yes, ma'am.
You quote 11, 11, 12, 13, 14, 15. Right?
Yes, ma'am.
Till 15. Reproduce. In the present case, it appears that the petitioner has been found guilty and the disciplinary authorities have awarded the punishment of removal by service on the basis of such inquiry, on the basis of such charges having been proved, when in the facts of the case it appears that the aforesaid charges are not made out against the petitioner. Stop. Though at the time when the inquiry officer had made the inquiry, has held the inquiry, the criminal case was pending against the petitioner, basis of which the Article 1 was framed against the petitioner. However, the criminal trial, in the criminal trial, the petitioner having been acquitted, it defies my logic and conscience as how the petitioner can be said to be guilty of the allegation leveled in the FIR, which the criminal court has acquitted him thereof. Therefore, the first allegation cannot be sustainable, it is not sustainable in law. As regards the second article also, keeping the principles as laid down by the apex court in the aforementioned case, comma, it appears that the finding of the departmental inquiry is totally perverse, since no such offense is listed under section 10 of the said act. Hence, this writ petition succeeds. Resultantly, the inquiry report dated 2/3/2015 and the order dated 30/3/2014 passed by the Commandant 48 Battalion Central Reserve Police Force are set aside and quashed. Accordingly, the respondents are directed to reinstate the petitioner in his service with all consequential benefits in accordance with law. Anything else? Any correction?
My friend was suggesting a time frame for the, otherwise.
What time frame for reinstated? Forthwith. Say forthwith. Reinstate forthwith.
In one of the matters when I filed a contempt case, when I filed a contempt case for non-reinstatement, Honorable Court was pleased to tell me that they will comply in a month.
All right.
That was it.
Later on, forthwith. It is needless to clarify that the respondent shall do the needful within a period of
2 months.
2 months from the date of receipt of the certified copy of the order. Case copy. I shall edit, so don't expect the order immediately.
Obligement.
Sorry, Ms. Gayan. Okay, that labor.
Obligement.
Yes. This is that Mr. Chaudhary's matter.
Yes, Lordship.
Yes, Mrs. Bhattacharjee. What do you have to say? Where is Mr. Das gone? Mr. Chaudhary's junior. He was supposed to be here.
Shall I start, Lordship? Lordship, they have contended that acquittal. One thing Lordship has to see what type of acquittal it is. So this is there in
Ms. Bhattacharjee, I think let them be here.
Yes,
It will
Lordship.
not be fair.
Yes.
Yes, there is one time being matter, Mrs. Bernali Chaudhary.
Yes.
Bhuya. Yes. Time being to be
Before starting by,
I may be allowed to call myself.
Yes, no problem.
before starting, my lord, lordship kindly I can draw lordship's attention at order dated 29/7,
29.
7 of 24.
What is this IA?
IA, my lord, I filed an IA for vacation of interim order or modification. She is the only rate petitioner is claiming only one post, and that too from serial number 2. I am in gradation list number 1, and by virtue of the interim order, my lord, my case is not considered. So what I filed, my lord.
Lordship is taking up the main matter or
I have
for
not
vacation of the
decided.
interim
I
order.
have not
Yes.
decided anything what I will do
Yes, my lord.
because you were not here.
Lordship.
So now that you are here, I will decide. Yes,
Lordship.
what do you want me to do?
It's up to your lordship. If your lordship takes up the application for vacating stay, he may
Main
be
matter.
heard
What
for.
is the issue involved, Ms. Bhuya?
Issue is your lordship. I'm working as
You first.
tourism.
You first. It looks like you've come running.
I'm working as Eastern Tourism Information Officer in the BTC.
Assistant
Tourism Information Officer. Now it is redesignated as
tourism officer.
Information Officer.
Information officer. Yes.
And now it is redesignated as Tourism Development Officer.
Tourism Development
Yes,
Officer.
ma'am. And my promotion, since I fulfill all the criteria, as per promotion to the post of Tourism Development Officer. Lordships, since my name didn't appear in the draft gradation list prepared by them, by the government of Assam, I preferred a writ petition because my name was not included. So during the pendency of the writ petition, government came up with the plea that my name cannot be included in the gradation list prepared by the state, my lord, because I was appointed by BTC. My contention is that BTC has got the power to appoint only grade 3 and grade 4 posts.
No, government's plea is that it is BTC.
BTC, because since I was appointed by BTC, appointing authority is BTC.
So it is BTC who can promote and
But-
not government. This
yes,
is the stand of the government.
Yes, and promote, and there is no like BTC do not have the power and to give appointment to any grade 2 post. Tourism
All right,
Development
all right.
Officer is
Now,
a grade 2
you
post.
have been appointed otherwise by the BTC.
Yes, my lord.
So now they are saying that BTC doesn't have that power.
Yes.
And that is why you will not be
Yes,
given that
my lord.
promotion.
So my name was not included. So my contention is that since BTC do not have the power to give appointment to grade 2 post, my name should include in the state gradation list, because for appointment to grade 2 post, APS's recommendation is required. And BTC do not have the power. Even otherwise, I fulfill all the criteria of promotion. In between, the respondents have come up with the application. The names appear in the serial number 1 in the final gradation list prepared by them, prepared by the government of Assam. So his case should be considered for appointment. My contention is that the criteria for promotion is, first, I don't say that I should be appointed, but my name should be included in the gradation list. Then thereafter, consideration is the different aspect of the matter. And apart from that, yes, criteria for promotion is merit cum seniority. Even if he is senior, his name appears in the number 1, in the serial number 1, the gradation list, doesn't have the indefeasible right for appointment, since it is a criteria of merit cum seniority. Merit will come first than seniority. That is the case, your lordship.
But what is your right, Ms. Priya?
My right,
it
your
appears
lordship.
that you have not been appointed by BTC.
I was appointed by BTC.
No, the plea that they have taken. Where is that plea?
Lordship, their
All
affidavit,
right.
my lord.
First, show me 2 things.
My
One,
lord.
where is the prayer?
My prayer.
Page
Page
31.
Yes.
Impugned final gradation list dated 30/12/23. There is a stay operating.
Yes. I submit, lordship, my prayer is that my name should be included in the final gradation list prepared by the government of Assam. They say there are two separate cadres, BTC cadre as well as the state cadre. There cannot be state within the state, your lordship.
Yes.
Lordship, may I take your lordship to the affidavit filed by them?
Undoubtedly, a detailed hearing will be required.
Yes, my lord.
This is not a matter.
Use ramification may be there, because
Yes.
they cannot just outskirt the lordship schedule areas. Here there's a move to outskirt.
Now, in the how many posts are there's a promotion?
Promotion.
To which post?
Tourism Development Officer.
And how many posts are there?
Altogether 5. I think they are included. They have already also included the post which is available
No,
in BTC.
how many posts are there?
5.
5.
Yes.
Suppose we say, yes, Mr. Counsel, suppose we say that you keep one post vacant, then they can continue with the filling up the others. We can modify the stay order and say you keep one post vacant.
Even if, Lordship, this person, his name is included in the gradation list, incumbent, private respondent. Criteria of promotion, merit cum seniority. Even if he is senior, it cannot be, Lordship. At least it's a defective gradation list, according to me.
Without considering
Yes,
your
my lord.
rights.
They should have given consideration.
Where is that averment in that affidavit?
Lordship.
One 193 government has passed the order. Page number 193.
1 second.
Yes, sir. Yes, yes.
Lordship, there are 13 number of vacant posts. I'm sorry, I will stand corrected.
13.
13. Page 165.
Page
165, my lord, their contention.
Well, the government has come with the plea, page 193.
1 second. Ms. Priya,
Of the affidavit filed by the government.
Yes,
that
I cannot hear two counsels together. Yes, one.
The speaking order passed by Government of Assam as at page 193.
Page
193.
193.
My lord. Where is Srimati Bhumarani Borbeari, Assistant Tourism Information
No,
Officer
this is
now?
constituting a central selection board.
Yes.
For? I can't read.
Mm.
Why such? Why it is not legible? These
Page
notifications.
193.
Yeah, 193, 192, 194.
No page to legible.
Yes, 193 is legible.
192 is legible. 194
yes.
is not legible.
Yes. Whereas
Where is Srimati Bhumarani Borgeari, Assistant Tourism Information
she
Officer?
is the petitioner.
Yes. Now, Assistant Tourism Development Officer, Tourism Department, BTC, Kokrajhar, has submitted a prayer petition to the undersigned in connection with inclusion of her name in the provisional state gradation list of Assistant Tourism Information Officer, now Assistant Tourism Development Officer, published by the office number so-and-so, whereas her name was not included in the state provisional state gradation list, Assistant Tourism Information Officer, Cadre of Tourism Development, BTC, Kokrajhar, whereas her state petition has been forwarded to the Tourism Development Department, Government of Assam, seeking necessary instruction regarding the inclusion of her name in the state gradation list of Assistant Tourism Information Officer by this office number so-and-so, whereas Tourism Department, Government of Assam, Administrative Department, Dispur, has submitted their views in connection with the inclusion of her name in a state gradation list, dated so-and-so, according to which her name cannot be included in a state gradation list as amalgamation of two separate cadres is not permissible. Hence, her name cannot be included in the state gradation list of Assistant Tourism Information Officer. And with this decision, the petition of Srimati Bhumarani Borgeari,
What is
Assistant
this
Tourism...
two separate cadre?
Lordship, there cannot be. Lordship, under the 6th schedule area, in the 6th schedule areas, the person working there, will they be outcasted from the state gradation list? Then Lordship, BTC do not have the power to give appointment to grade 2. So approval of APS is required. So in the event of the matter, whether they will, it will remain, it will Lordship be, there will be a stagnation of service.
Undoubtedly is government,
Yes,
is a
my
state
lord.
of government
Yes.
employee. Only thing he has been appointed in the
by the
BTC. But that is a state subject.
Yes,
It
my
is,
lord.
this is not their inherent subject. That's paragraph 3.
Tourism is a tourism that the subject has been transferred to us, but power to give appointment only as regards grade 3 and grade 4.
So it's a transferred subject.
Yes.
So that means the government role is still there.
Yes.
It's
Finance part is from them.
correct, because
Yes.
it's a transferred subject,
Yes.
right?
Yes.
Then how can there be two cadre?
My lord, government has filed, my lord, I'm not also,
BTC areas are within the state of Assam.
my lord,
It is not outside.
that is within the Assam, that is the
Then-
no problem for that. My lord.
No, but then this is the ground on which
Yes, my lord.
her case has not been considered.
My lord, that all coming, my lord. Final gradation list was prepared by virtue of the order of the Honorable Court, my lord,
No, but
page
before
205.
we go to all that, this document at 193, because
Yes.
this document speaks. This is the speaking
That has
order.
not been challenged by her, my lord.
What has been challenged?
Petitioner has not been challenged. Lordship, kindly have a look there. They filed a 2 writ petition, and what they challenged, my lord.
They are seeking for promotion.
My lord. Lordship
Correct.
will
My
see-
lord. And this speaking order is not communicated, or it is communicated.
communicated, my lord. Lordship will see in the first.
This order is not put to challenge. Ms.
No.
Priya?
No.
This order was not put to challenge because this communication, which they have already, Lordship put it on record in the earlier writ petition, if I'm not wrong, my lord. And we have only my prayer that I should not, that my name should be included. Appointment and promotion is different aspect. It will come later on. But whether I would be outcasted from
So
like
here, if I understood correctly, Ms. Bhuya, her grievance is that non-inclusion in the list.
Yes.
She is only aggrieved by that. She says that she should be also included in the list. Now it appears reading of this document at 193, one of the reason, subject to what you say, appears that her name was not included in the list because it cannot be included because of amalgamation of 2 separate cadres, not permissible. What is this 2 separate cadres that they are talking? This the government has to explain.
Yes,
You are
ma'am.
for the private person.
I'm the private person.
Yes, government. Where is he? No, but you see, before I hear the private person, it is the government who has to explain these. How can there be, where is the question of excluding the petitioner? Petitioner is also a government employee. Is under the state of Assam. How can there be 2 lists?
Lordship permit.
I'll come to you, but you see, it is the government's order. It is you are not giving promotion or including, excluding, correct?
My lord, my right has been affected. my
That we will come. Definitely, we will not conclude the hearing without hearing you, but primarily it has to be the government who has to satisfy this court.
We have filed our affidavit. In that, we have stated that both the eligibility criteria for both the posts in the state as well as in the BTC are different. The entrance.
Wait, paragraph
And paragraph 4
of your affidavit.
of my affidavit.
Get ahead.
This
The answering
affidavit that
deponent
you are
begs to state
referring
that-
is of R3.
152 page number
No,
of R3. R3.
Yes.
Paragraph number 4, that with regard to the statements made in paragraph 2 of the writ petition, the answering deponent begs to state that as per the Boroland Territory Council Secretariat Kokrajhar notification, paragraph 4,
Yes. Yes, please.
dated that with regard to statements made in paragraph 2 of the writ petition, the answering deponent begs to state that as per the Boroland Territory Council Secretariat Kokrajhar notification number dated 37/2007, the powers and functions of the Central Selection Board are mentioned in clause 4 of the aforesaid notification as follows. The Selection Board shall abide by the Boroland Territory Council service rules in respect of recruitment of personnel for BTC Secretariat and such other rules now in force in respect of recruitment of personnel of 40 transferred subjects. The answering deponent further states that as per the Schedule 11, Rule 10 of Assam Tourism Service Rules 1992, now Assam Tourism Service Amendment Rules 2023, the minimum qualification and experience prescribed for direct recruitment to the post of Assistant Tourist Information Officer is as follows. A degree in arts, science, or commerce of a university recognized by the government. The candidate should be capable of expressing himself in English properly and fluently, as he will have to deal with foreigners and tourists from other states of India. Whereas the required qualification for the post of Assistant Tourist Information Officer BTC mentioned in the advertisement published on 3/11/2011 was the minimum educational qualification is graduate in Arts, Science and Commerce, Diploma in Tourism or Hotel Management from the UGC recognized university, proficiency of language in English, Hindi, Assamese and Bodo. Candidates
They are
shall
same.
Also, we have got additional qualification.
additional
Ms.
qualifications are
Counsel, yes,
required.
Your name?
You, Sharma.
Ms. Sharma, the qualification that is required for the post of Assistant Tourist Information under the state, yes, your senior is there, but you are doing well, is a degree in art, science or commerce of a university recognized by the government, correct?
My lord.
This is the degree?
My lord.
Now, as far as BTC is concerned, there also it is there. Minimum
A further
educational
diploma in tourism also is also
Huh?
required.
So that's an added in BTC. How is it affecting you in state? All right,
And
Mr.
further,
Nath.
candidates will have to have 3 years of working experience also. And use of computer and online marketing. of
These you are
tourism.
referring is from the BTC, correct? Mr. Nath, you are appearing in this matter? Yes. See, Mr. Nath, the issue, the question that is troubling this court is how a person in BTC can be said to be excluded merely because he is serving in BTC in a select list prepared by you for the same post, because he or she is also otherwise under some transferred subject, understood, but it is a state within state only. It's not outside. BTC is not outside.
That is one
Correct.
Aspect. That is one aspect.
That is
True,
one
true.
aspect, and that is the main aspect.
True.
Now, your Ms. Sharma was trying to convince this court by showing that the qualifications required are different. But if you look into at page 153, the main qualification, that is the degree in arts, which you need for a person to be qualified for that post in Assam, is also there for BTC. Now for BTC, there may be some added, but for the as far as the state of Assam is concerned, what you need is there. Have you followed what is falling from this code?
yes,
I could have understood. I could have understood if there is something more as far as one working in Assam is concerned. Then one could have said that the person does not have it. But here it has it. And the speaking order at page 193, it talks about this, that it cannot be amalgamated because they are two separate cadres. What is this two separate cadres? This is troubling this court. This, because you see, it's a serious issue. It might have large ramifications and consequences.
It's a serious issue, and it has a because there are two cadres according to what they have said that
they have said means.
But it's stand taken in page 193.
Yes, that is you.
Yes.
You're appearing for director of tourism.
Yes,
no,
yes,
you said they, so
No,
I got
the
confused.
The authority. But here they have said that the persons who are working in BTC, because the controlling authority and the appointing authority for grade 3 and 4, they are the BTC people. They are maintaining the records and everything. So there is no amalgamation. There is no amalgamation at one point. One gray area I also find, but that has to be current.
That has to be
looked into.
That is what is required to be looked into, because it is going to. How can you discriminate merely because this person is, because all that the petitioner is seeking before this court is is for including the name of the petitioner in that gradation list. That is the limited prayer.
There is one issue that if the person is incorporated in the All-Assam, in the cadre which is maintained by the directorate for the state, in that case, she will she will be in the cadre of All-Assam cadre, and she will come out of the BTC.
How will she come out from the BTC?
No, because
don't you have these transfers A person appointed there will always remain there. That person cannot come out from BTC.
But
I
that-
think these are transferable.
That amalgamation is not in this directorate, under this directorate, that amalgamation is not there because it is transferred and the tourism is with them.
No, it's a transferred subject.
It's a transfer subject.
So you still have the control. You are the financer. You are financing it.
But the
Yes or no?
Finance is with
Yeah.
the advertisement and
So these are not those. What is the other subject called? Normal subject.
normal subject.
So this is not a normal subject.
It's
This
not
is
a-
transferred. If it
Yeah.
was normal, different. Then of course, what you say definitely makes sense. But this is a transferred subject. If you are not prepared, we'll take it on another date. But these questions has to be addressed.
Yes.
This court is not just confined to the rival contentions of these private parties.
No,
But it has a
considering the issues raised, ultimately the stand taken in the page 193. Now the entire issue is that whether the petitioner has to be there has to be one cadre and the amalgamation of cadre.
Correct. That is the issue.
That is the issue now cropped up.
Because you see, if it is one, then the petitioner has to be included.
Yes, my lord. And they are
Correct.
not. They are not.
And if this
they are not
court comes
accepting
to
that.
finding key, what you all are contending is correct,
True.
then of course the petition is not meant. The petition will not succeed.
Malad,
So I think let us confine to this basic question first.
Ultimately,
It
that
might
is-
need you might have to burn some midnight oil.
Definitely.
Because it will you will not get these answers readily. Maybe the sixth
Readily.
schedule will also have to be looked into a
True.
little. And let's go into the depth of the matter
Yes.
because
Yes.
of the larger ramification that it
Yes.
involves.
Correct.
When can we have it?
Malad, if not inconvenient to your lordship, Malad, after the
It's not about the inconvenience of this court. This
No,
court is
immediately-
available every day. It is about you, the parties. When can you have it? Because it is you who have to address this court.
Immediately after the reopening, Malad.
You see, your IA cannot be considered
My
at
lord.
this stage. You
My
you
lord, I
understand.
just-
So everything will be taken up together.
Yes, my lord. I agree with your lordship, my lord. My only my contention is that, my lord, I was appointed in the month of December. February. And she was appointed in the year February, my lord.
You were appointed when?
I was appointed in
December,
February.
huh?
February.
February.
And she was appointed December. 8 months, 10 months later than me, my lord. And in her petition also, she is claiming, my lord,
What
serial
is
number.
it is merit
Merit
cum
cum
seniority.
seniority.
Then
Even though she cannot come, my
I'm not.
Our prayer is-
no, but how can this court at this stage go into all that?
No, my lord.
This
Her
is
prayer-
only about the issue is about inclusion.
My lord.
How can you object to her inclusion?
No, I don't object to that. That
You
will
know,
be
the-
included, my
the-
lord. I
the,
don't have
authorities will consider that is a different stage.
But her prayer, my lord, lordship, can you have a look, my lord, two prayers for a moment, my lord.
Yes. Page.
First prayer,
Page
my lord,
31
the second read
onwards.
petition 695, at page 32.
Inclusion only.
Page 31.
659.
My lord.
Page.
Page 31
32.
onwards.
31 operative plus 32.
3-1.
3-1 and 3.
3-1, your lordship.
Yes.
Then lordship turn
Yes.
to next
Include the
page.
name of the petitioner in the final gradation list. It's there.
And challenging the this one
And
final
she
gradation is
asked
because
for
my
one
name is
post
not
to
there.
keep vacant post in the cadre of tourism. Specific prayer.
It's
And
all-
other prayer, my lord, in the other read petition, lordship, kindly have a look the prayer. That is 5568,
Prayer to legacy.
page 18.
One second. I don't have the record of that writ petition.
My lord.
WPC.
55.
WPC 5568.
Page 18 and 19.
Page
18, my lord.
18.
My lord.
Yes.
Saying that Impugn letter so and so.
Impugn
That would-
gradation list, impugn final gradation list, impugn letter.
Yes,
Include the name of the petitioner in the draft as well as final gradation list.
my lord. Then, my lord, the honorable court, my lord, by order dated, my lord, lordship will see from the record, order dated 7/12/23
In which writ?
in the common, my lord, order.
7.
5568. 5568.
768. Order dated 768.
No, my lord. Writ petition 5568/22.
No, no. Order dated
Order dated 7/12/23.
7.
12/23.
There is no 7/12/22 here.
It is there, my lord. All lordship can have a look, my copy.
No, no. We'll take out. Right.
হৈ যাব ন বহা নাই নতুন নাই নেকি?
মই এটা এনেই ৰখি আছো আপুনি আহক কিতাপটো লৈ আহক
7/12/23. It is there.
ডিটেইলটা ফিক্স কৰিব আৰু কি কৰিম মোৰ মনত লিপষ্টিক এটা টেষ্ট আছে পৰা
বুঝতে পারছি স্যার দেখাইলো
ডেটা কিছু কন্ট্রোল না বোর্ড করে পাচ্ছেন
So liberty was given to publish the final
Yes,
gradation.
that has been done.
That has been done.
Done.
That is
That
under
is
challenge
challenged by
And that is challenged
Yes.
in
in
the
the second
subsequent.
in the second case. In the second case.
Now, my lord, my prayer will be, my lord, subject to the outcome of the writ petition, my lord, any modification, some
No, no. This court is considering this matter for hearing. It's a
Yes, yes.
serious issue that has cropped up. Yes. When can we have it? You will come up with a date.
Let it be immediately after reopening.
You write in all the WPCI everything. Huh? Heard MS B. Bhuya, Learned Senior Counsel, assisted by MS B. Bora, Learned Counsel for the petitioner. Stop. Also heard Mr. D. Nath, Learned Senior Government Advocate for the state respondent, Mr.
J.I. Barhuya.
J.I. Bordhuya, Learned
For
Counsel,
private
appearing for the private
private
respondent. Stop. Due to paucity of time, this petition, no, don't say that. Huh? During the course of hearing of the writ petition and the interlocutory applications, it appears that the name of the petitioner was not included in the final gradation list as the petitioner belongs to a separate cadre of BTC. Stop. This court is of the prima facie opinion that the subject post the subject post that the post which is the post in question is a transferred subject shall not cannot be considered as outside the cover of the outside the cover of
Director of Tourism.
of the Director of Tourism Assam.
Economic days.
Stop. No, this I'm saying I'm also of the prima facie of the same view. You see, you cannot. Be that as it may, as prayed for by Mr. D. Nath, learned Senior Government Counsel, post this matter again on such and such date
There is no 7th of
for
November.
further hearing, and also to enable the Senior Government Counsel to apprise the court as regards the said issue. I have confined it to that right now, but you all will be at liberty to argue as you please. Date
7th of November, subject to your lordship's
7/11/2024.
Lordship interim order should continue.
Interim, if any, shall continue till the next date of listing.
Obliged.
Mr. Das.
There's a matter going on in court number 20, Lordship. I was taking note there.
No worries. Then let's have it on another date. I kept it thinking I can
Part heard, Lordship.
I'll dictate the
Yes,
judgment,
Lordship.
but
Lordship.
it doesn't appear that I can.
But except on Wednesday, Lordship, I have
When-
some
when
outstation
you want?
cases. No, any date, Lordship. I have no problem.
Lordship, the anxiety only I have.
Monday?
Lordship,
Yes, Lordship, it can be.
maybe on Tuesday, Lordship.
Tuesday. All right. It Tuesday ki ba asa nahi?
If it is not inconvenient for the court, your Lordship.
Nine,
It is
right?
something
Tuesday.
to be done.
So there were three decisions that you all had given. No, you from your side, Mr. Das, GM Tank and Paul Anthony
Paul Anthony, and one more judgment, if it is required, we'll place on Tuesday, your Lordship.
on Tuesday.
Lordship.
I think Ms. Bhattacharjee, you will have to confine to that.
Yes, Lordship. My
Mr. Chaudhary, we're posting it on Tuesday.
Yes, Lordship. My there is also, I also have one judgment, Lordship, where this same set of things, the Supreme Court has clearly stated, Lordship. There's
Clearly
already
said
been
what?
that it can be, Lordship.
No, that perhaps would depend on the, that is why
Situation,
you
yes,
see the
Lordship.
situation.
Yes, Lordship.
There could be a situation where, because the standard of proof, there
Yes,
is a
Lordship.
difference, right?
Yes, Lordship.
Standard of proof cannot be the same
Yes.
in a criminal and a
Yes,
departmental.
yes.
So before one says that
Yes.
because of the acquittal, this will not lie, one
Yes.
has to apply
Yes.
one's mind and see what is first of
Definitely,
all the
Lordship.
gravamen
It
of
depends
the
on
charges.
situation, yes.
Correct, the charges, and how it has, if the suppose it has clearly been proved in the criminal trial that this has not been done, then how a disciplinary proceeding can.
Lordship.
Just before this, after your matter, there was another matter where I have just dictated. In that case, the first charge was that the delinquent employee was found in a state in a state of intoxication at a public place in view of the FIR. Now, there was an FIR that he had had a scuffle with the informant's son, but the criminal court acquitted him. Then where is the question of the department?
Similarity of the facts.
Correct. So one has to apply to those facts, right?
Lordship.
Now,
Anyway.
in this case, my lord, I have demonstrated
That they are same.
line by line the allegations
You
are
have
same.
said that the
same
list
set
of
evidence.
witnesses are same, the allegations, the nature is same.
Circumstances same, same set of witness.
So now perhaps the question that will come in is how the criminal court has acquitted
yes.
you, and
Yes, Lordship.
whether you see, if we go by that, whether that is
Lordship.
satisfactory. Maybe that much exercise has to be done.
Yes,
perhaps. Tuesday,
Lordship. You can.
further hearing, no?
আৰু এটা ৰৈছে সেইটো কৰি পানে আজি মানে ডেটটো মই কোৱা নাই
Tuesday.
Yes, Lordship. This one. Another case is with
Today?
senior. Sorry, yes.
Before
Lordship.
this court, which one?
Yes, Lordship was
Lordship has heard the matter at some length
Which is
yesterday.
this?
Shamsul Haq Talukdar.
That, my lord, we are relying on the Deepak Mali's case.
Oh, that suspension.
Yes, Lordship.
Yes. Dasani. There, I think I had asked you to give those dates.
Lordship,
perhaps.
Regarding the date of suspension and all.
Yes, Lordship.
Yes.
But dates, Lordship, I could not gather because
Because
the,
I think one date was mentioned in that
Yes.
subsequent extension, right? That
Yes,
1906
yes,
something.
Lordship, the petitioner side, they were telling that within 90 days, Lordship. But I have a notification where it is 6 months, Lordship,
Huh? 6 months.
regarding review,
No, my lord,
Lordship.
that
And
that
this,
notification is in variance with the Supreme Court judgment.
and Lordship, this has been dealt in one of the case of this coordinating bench, Lordship, in Prasanta Datta versus the state of Assam
No,
case.
but first you explain this, how this date has come.
Lordship,
was
the date part I could not take,
That
Lordship. This is
1906-24. That was
Lordship.
the date, right, Mr. Chaudhary?
Yes, yes, yes.
Yes, because you had submitted that expires on 29/3/24.
Yes.
And here it appears it was further extended with effect from
Lordship.
19/6/24.
Lordship.
What happened in the interim period?
Lordship, that I
Because
could
if
not
there was
take.
no extension, then
Yes, there were extension that I am.
they were
There
not
were
on,
extension, Lordship.
they were extended or they were not extended.
No, it was extended.
It was extended.
Extended, Lordship.
So you have that.
No,
then-
issue is whether prior to that date there was an
No,
order
no,
of
that,
review.
that is what I'm saying. See, these extensions and this review has to be continuous. There
Lordship.
cannot be a gap.
Lordship.
The moment there is a gap, then they
This
get the
will-
benefit. I
Lordship,
think this is what sum and substance of
Lordship,
your
then
argument, right, Mr. Chaudhary?
This one also, Lordship.
My lord, my humble understanding of the law is, if you want to extend the period of
You have to do it before it expires.
suspension beyond 90 days,
Before it expires.
whether you have submitted a charge sheet or not, there is a requirement of reviewing it and passing an formal order.
As of now, prima facie, I agree with you.
Yes.
Because merely because a charge sheet is given doesn't absolve you from continuing with the suspension for an
Exactly.
indefinite period.
Yes,
That
yes.
defies the entire object and logic of keeping that suspension and reviewing and all that.
Lordship.
I don't agree with that because there are a lot of cases where
that is the
after the
understanding.
charge sheet, the final order takes 1 year. And all throughout, you do not even review,
Sir,
do not even extend.
Lordship will kindly apply one more principle in this case. The recently Honorable Supreme Court has passed so many orders in case of bail. Despite Section 37, despite the bar. Why? Because end of the day, if one has to incarcerate, in that case, there is violation of Article 21. In which case, the parliamentary laws prohibition will not come in the way. Because end of the day, there must be a speedy trial. Same principle applies here. What is Milord Ajay Chaudhary? 167 two principles were applied.
No, there prima facie, because it defies the logic otherwise.
Exactly.
Because what is the object of suspension? So that in a fair manner, the inquiry is done. If you are of an opinion that
Idea is not to punish.
Correct. This is not a punishment.
Lordship, I am also praying this to be taken up on Tuesday, if it is convenient to the senior counsel, Lordship.
This is also
Because
part
the
of
date part I could not take, Lordship.
give the possibility of time further hearing on Tuesday. Part heard, huh?
Okay, further hearing.
Rupak.
That's a further. Lordship is giving a further
Yes,
hearing there.
yes,
Lordship.
Deeply.
Deeply obliged, your Lordship.
ওই গ'ল না আছে আৰু
May I please, my lord? My lord, in this case, I am on behalf of Mr. DC Bora, my lord. My lord, in this case, what happened, my lord? The client already taken away the brief from the Angus
Oh.
Council, my lord. The long back, 2021, my lord.
Brief has been taken away, Mr. Upadhyay.
Lordship. Otherwise, also, Lordship, the case, the petitioner here, Lordship, he is seeking Lordship regularization, Lordship. After Uma Devi and Upen Das, Lordship.
Have you, no, but if suppose the brief has been taken away, what is to be done? They have not, have you
Engaged-
filed an affidavit?
No, my lord.
Why don't you put an affidavit that the brief has been taken and then we can close this matter?
Yes,
Because, your client has not re-engaged anybody, it appears.
It appears not.
It appears.
Not.
So either you send a certified copy letter where you inform some step you show, then we can close it. No?
Yes, my lord.
Your name?
KM Hassan.
Mr. K.
M. Hassan.
KM Hassan, learned counsel for the appellant submits that the petitioner has taken the brief from them. However, it appears no.
Lordship, second copy with me, Lordship. There is no occult knowledge.
However, it appears that no alternative counsel has been engaged in the matter till date. Situated thus, the petitioner is given let an affidavit to the same be filed before this court by the next date of listing. You put it by way of affidavit. And present N. Upadhyay,
Lordship.
Standing Counsel Irrigation.
Lordship.
List again when? After 3 weeks? 3 weeks or so.